Good morning. We're going to now begin the meeting of the Labor and Public Employees Committee on this Thursday, March 12th. And we have a somewhat short agenda for the Labor Committee. However, I'm sure some of these issues will be generate a lot of conversation. So I am going to ask if my co-chair wants to make any comments. Ranking members, do you have comments? Representative Weir, do you want to make any comments? Okay, with that, then we'll begin with item number 3 on the agenda, bills for review. And the first item on the agenda is Senate Bill number 350, increasing the per diem rate for members of the State Board of Labor Relations and compensation for members of the Board of Mediation and Arbitration. This is a JF to the floor. Is there a motion? And is there a second? Let me look online here. I'm sorry, I wasn't logged in yet.
Recording in progress.
Okay, I apologize, but we're going to have to hold on for a moment.
I second the motion.
Thank you, Representative Hughes. This is a bill that will address the compensation that we pay for the important members of our mediation service. And I know that there's been an effort to do this in the past, but it will raise, at the conclusion of the proceedings, each member of the panel will receive, instead of $325, $500, and instead of $500, when they write the decision, $1,000, and or if it's a single member, that they would get $500, provided if the proceedings extend beyond 1 day. It's very specific, in which case they get $500 for each additional day beyond the first. So with that, are there any questions or comments? Representative Mastro-Francesca.
Thank you, Madam Chair. I'm just curious, a couple things. How many members do we have, do we know, for the Board of Mediation Arbitration and for the Labor Relations Board? Do we know
I
how many
don't
members?
have that number. I'm sure we could get that for you.
Okay. Do we know, through you, Madam Chair, the average amount of hours that they put in a year? Any idea?
I don't.
No.
I know they probably work hard for the cases that they have, but I don't know how many hours they put in.
And I'm just curious, do we know what the average annual salary is or per diem for each one of these members?
I don't
Do we
have
an
that
average?
information, but I'm sure when we JF this bill, that we'll get that information in a fiscal note.
Thank you. So is this bill going, based on the answers you've given me, I don't really know, I would assume, are we JFing this bill to appropriations?
We're JFing this to the floor, but I assume when it goes through screening, it will get referred.
Okay. And I don't know if I obviously go back and look at the testimony. I mean, it would be good to know ahead of time before voting on something like this. You know, what is the average pay that they're getting? How many average hours are they working? How many people are on these boards? So we kind of have a dollar figure in our head or something of the potential cost on it. Okay, so I'll be a no on this today, but thank you for answering my questions. Thank you.
Certainly. Any other comments or questions? Okay, seeing no hands, I will ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 1, Senate Bill 350, an act increasing the per diem rate for members of the State Board of Labor Relations and Compensation for members of the Board of Mediation and Arbitration. This is a motion to JF to the floor. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson. Senator Sampson.
Sampson is no.
Representative Weir.
No.
Representative Hall. Representative Hughes.
Representative Hughes, yes.
Senator Lesser.
Senator Lester, yes.
Senator Lesser, would you mind turning on your camera?
Sure have.
Thank you. Representative Canino. Representative Gauthier.
Yes.
Representative Mastro Francesco.
No.
Representative Shake. Thank you, Madam Chair.
Thank you. We'll be holding votes open, and we'll determine the time at the conclusion of this public, after we've completed the items on our agenda. Now we'll move on to item number 2, Senate Bill number 355, an act concerning limitations on the use of non-disclosure agreements. Is there a motion?
So, second.
And this will be JF to the floor. Any comments or questions? Senator Sampson.
Thank you very much, Madam Chairman. This is a bill that we've had before the committee a couple of times before, and in fact, it's also been before the Government Administration and Elections Committee in the past. And I've always opposed it, not because I disagree with the stated purpose of this bill, which is that we're trying to protect victims of effectively criminal behavior in some cases, sexual assault, etc. Obviously, we would like to do that. My concern about this legislation as proposed is that every time I see it, it always has the same, what I think is a very important and very significant flaw, which is that it denies the right of the victim to make their own decision. There are a number of other concerns with the language of the bill, and certainly things worth discussing. So maybe I'll cover some of those. But while we're talking, I want folks who are listening to remember that for me, this policy works very well up until you reach the key ingredient, which is we're denying the right of that employee to make their own decision about what's best for them. And in my view, that is something that we should not tamper with. The victim, if we want to use that term in this particular case, they should be able to decide whether or not they want the behavior to become public, whether they are exposed as a victim or otherwise, or they prefer to keep the option open of entering into a non-disclosure agreement. I think that the reason why NDAs exist in those cases is very often because the victim doesn't want the notoriety or the public attention of what occurred. And certainly if it works to their ability to receive compensation where they might not in a case where there's a criminal prosecution, they might choose that as an option. And I can understand people that think that that's a bad policy or bad precedent because it allows people that engage in bad behavior to go without prosecution. And I think that's a viable argument to make, and I don't want to dismiss it. But I don't think that outweighs the ability of the victim in those cases to be able to make their own choices. So I just want to clarify a few things. There are some other issues that even if I agreed with the policy as is, I would just caution against. The first thing I would ask about is current existing employment contracts that include NDAs or NDAs that are entered into separately from their employment contracts that are pre-existing today. Does this policy language that's before us retroactively void those contracts, Madam Chairman?
Thank you, Senator Sampson, for that question. I know that I want to find the right reference to that, but I do believe there is a reference to existing agreements. Yep. Right.
You got it.
So under this proposed legislation, if an agreement was entered into prior to October 1st, it shall be void and unenforceable only where such provisions was entered at the outset of employment or during the course of employment. For a prohibited non-disclosure, non-disparagement provision, void and unenforceable under this subsection, the only recoverable damages would be relating to the enforcement of the provision. The provisions of this subsection shall not apply to any agreement that was contained in an agreement to settle a claim. I think that's your question, correct?
Yes, ma'am. Although it generates a couple of other questions, but the short answer is yes. This language has the potential of voiding existing agreements, but I do appreciate there is some additional language that is, I'm guessing, intended to protect things that may have been agreed to in the past. So I'm just trying to understand the rest of this paragraph. If there was a situation that occurred and the parties entered into an NDA and maybe the employee received some sort of compensation, and this does not have to be a criminal item. This could be just any activity that they felt that they did not want to make public. Does that mean that the amount that the employee received as compensation for signing an NDA, and I suppose it could work the other way. I think an employer could also receive compensation from an employee under the, might be odd circumstances, but I think it could happen where, one of the parties offers the other party compensation in exchange for a non-disclosure agreement. Does that mean that the contract's void even though money changed hands, which mean there'd be no repercussions for violating the NDA if this bill passes? Through you, Madam Chairman.
I'm not sure I 100% understand your question because it was a long one. So maybe you could summarize and give me the question again.
Sure, and I'm sorry, I kind of
That's
got caught in thought while I'm developing the question. But I guess the short question is, if there was a prior agreement between the parties to sign an NDA in exchange for compensation, does this bill void that contract despite the fact that money might have already changed hands? In other words, could they keep the money and still break the agreement through you?
I believe this would allow for that, yes.
Thank you very much, Madam Chairman. That's concerning to me. We've got people who are outside of this building going on with their lives as free citizens, we hope, although I question that as we continue to make more and more policy that deviates from the notion that they're free adults able to conduct commerce on their own. This committee seems to think with the extensive amount of legislation that interferes in private contracts that people are not capable of conducting those agreements themselves. And this is another one. I want to understand the compelling state interests, which is a requirement in our laws that when we make legislation, we have to have a compelling state interest for why we're doing it. What is the compelling state interest with voiding an agreement that was entered into by parties voluntarily where one side was compensated? Through you, Madam Chairman.
I think it's in the public interest that even in those cases, the prohibition on disclosing the behavior and the things that happened to that person in the workplace, that prohibition, it's against the public good. If in fact, as you stated in your opening, that you share a concern, that it allows that behavior to continue perhaps to another individual.
Well, thank you very much, Madam Chairman. And I understand what you're saying, except that this doesn't necessarily apply to something that is criminal in nature or sexual abuse or anything like that. This applies to other things too. There could be other embarrassing activity, perhaps. Maybe someone's behavior at a party. Maybe that's the employer's behavior, and the employer's willing to pay the employee, or maybe it was the employee's behavior that they want to protect and ask the employer upon departure not to disclose. That doesn't sound like something that might happen in most people's day jobs, but I know that one of the main proponents of this legislation is a former employee of a large news organization. So they're effectively a celebrity themselves. And in situations like that, I think that people like that certainly have lawyers to review their agreements and so forth. They don't enter into anything without having a full understanding of exactly what's happening. But this effectively could say that an employee couldn't, if they paid an employer to not disclose their behavior in some way that might embarrass them, especially in a situation like that where you have an employer and a celebrity employee part on difficult circumstances, if you're going to void the agreement, even though the money's already changed hands in exchange for that silence, you're opening the door for people just to share all of these secrets that were paid for. And I would just like to make a distinction that this is not just criminal or really abhorrent behavior like sexual assault. It does include other items. Is that correct through you?
Thank you for that question. It does include other items, but those items are all a matter of violations of law. None of them are frivolous. So the items that are covered, it prevents, it voids an agreement if it restricts the person from discussing discrimination, harassment, retaliation, wage and hour violations, sexual assault, or other conduct that violates public policy.
Thank you very much, Madam Chairman. So are you suggesting that the lines contained in that paragraph that begins on line 383, I guess it's subparagraph F, where it simply states any agreement that was entered into prior to October 1st, 2026 shall be void. And it says at the bottom of the paragraph, provision shall not apply to any non-disclosure or non-disparagement provision contained in agreement to settle a legal claim. Are you suggesting that this paragraph is also subject to the terms that are contained elsewhere in the bill that say that the only unenforceable agreements have to do with criminal behavior?
Hold on, I want to make sure with LCO that we get you the right answer.
No. No.
Thank you. Thank you for allowing me that moment to make sure. It is often hard to make sure we know everything that's related back to. But if you look at lines 333, that's where it describes what becomes a prohibited agreement. And then when you go to the line you questioned in 383, the final line on starting on 390, it says the provisions of this subsection shall not apply to any non-disclosure. Oh, no, that's not the right line. Oh, I know. It's the first line, 383, a prohibited non-disclosure. So by saying a prohibited non-disclosure or non-disparagement provision, it references back to the description of what is prohibited.
I appreciate that, Madam Chairman, except for the fact that you have written this bill in a way that does not define criminal behavior as legally impermissible. What you have done is you have written this bill to allow the employee to decide what's legally permissible. If you go to lines 333 to 352, it says that any provision in an agreement between an employer and employee or volunteer to disclose or to discuss conduct that the employee or volunteer reasonably believes, this is the operative term that's in this bill and it's used several times, it's what that employee or volunteer reasonably believes under state, federal, or common law to be legally impermissible, and then it describes those items. But what is defined as an unenforceable or void contract on line 340 and 341, where it says shall be void and unenforceable, that points back to what the employee reasonably believes. So why are we giving the employee the ability to determine what is legally permissible? Through you.
The language that describes what a person reasonably believes is a standard that is used throughout our legal system, and it's well understood by lawyers and by judges. If an employee reasonably, an employee will have to prove if in fact they were to disclose something that happened in violation of their agreement, they would have to be able to prove that they had good reason to believe that the activity was described as no longer permissible. And so I think that that an employee who takes that action is maybe going to have to prove that it was reasonably believed. And I think the words reasonably believed are accepted language in most courts and an interpretation of law.
Thank you very much for the answer, Madam Chairman. I know that reasonably believes appears throughout many of our legal statutes, and that's understandable since the legal profession permeates the legislative membership, and they have a very powerful lobby. And this particular bill is a litigator's dream. This is an opportunity to make all kinds of money and fight over what reasonably believes means in court. That's why we often don't see bills that are written in clear language. It's all designed to make sure that this ends up in a courtroom where a bunch of lawyers can make a lot of money arguing over what someone reasonably believes. And that's really sad, because now we're talking about the fate of individuals that are trying to conduct business, whether or not they are subject to defamation by having their words misused against them or their behavior described in nefarious ways. And as I pointed out, Madam Chairman, my larger concern is that you've put all of the focus and legitimacy in the hands of the employee. And I don't understand why. I described a set of circumstances where the employee might be the one going to the employer looking for an NDA because they don't want their behavior to be exposed, and they're willing to pay off the employer for that purpose in a non-criminal situation, but maybe an embarrassing one. But we've left it up not to the employer to determine whether things are eligible to be void, and therefore keep the money and run and still expose that employee or not. I think it's a very poorly conceived way to do this that entire paragraph is all wrapped up in what the employee reasonably believes, instead of an objective standard that any reasonable person on the outside would say. I think that that's the way it ought to be written if we were trying to be responsible. We would say behavior that a reasonable person would believe is legally impermissible. That would make much more sense. I'm just throwing that out there as a recommendation if this bill moves forward, that let's be a little more careful about who we are allowing to make the subjective determinations.
Thank you. I think that what we're trying to get at here is to make sure that an employee who separates and has signed a non-disparagement agreement or a non-disclosure agreement, if they determine that if something terrible happened or something just violation, maybe it wasn't the abhorrent behavior that we've heard expressed, but maybe it was a violation of law that they were not, that they would have the ability to move forward and disclose that. Now, if there's a better way to write this that gets at, that allows that freedom or gives that permission to that employee to violate that agreement, bring a case forward, if there's a better way to write it, I don't think we're opposed to that. So, this may be one area where we could find a better phrasing of that, as long as we're not changing the ability of the employee to pursue other remedies. And hold on, this is a little weird because I know we're going back and forth, but I see that Representative Hughes would like to enter into this discussion. So with your permission, I will allow.
Madam Chair, thank you, Madam Chair. I just wanted to weigh in on a couple of things and that my good colleague does bring up.
Representative Hughes, as long as it's pertaining directly to what he just said, I'd
Yeah.
like to prevent a back and forth that's disorganized. But if you're speaking directly that will help answer the question he raised, I'm fine with that.
Just to clarify, a lot of these NDAs are prospective and expected upon, contingent upon the employment, or at least expected, right?
I don't think we're at that point yet, but you can raise that when we get through with Senator Sampson's comments. But he's right now been directing his comments
Okay.
to agreements that were done on separation. Am I correct? That's correct. So let's stick to that for the moment. Thank you.
I'll save my
Thank
other
you.
couple of comments to weigh in on this conversation, but I like it.
Okay, fine. Go ahead, Senator Sampson.
Thank you very much.
I know that was a little risky, but I thought I would.
Yeah, no, I'm open to the conversation. Look, I wish we had more of this, to be frank with you. I think there's not enough actual debate going on in our committee meetings where we can actually come up with real live concerns and maybe unintended consequences, and we can head them off by crafting better language in a bill proposal. I'm extremely sympathetic to the people that came before us, and over the last several years, it's not been a good feeling for me to vote against this legislation. I want to support people that are coming to us looking for help, but I also have grave concerns about overstepping. And certainly the area where I think we're overstepping more than anything is in the case of where you have the employee actually wants to engage in the NDA. And I think that this ultimately prohibits that because it doesn't allow them to enter into an agreement, even if they choose to, depending on the extent of the behavior. And I really just think that choice belongs to them no matter what. And I get that some people might have a different view because they want to make sure that we are prosecuting bad behavior, and I get that too. But for me, that is the tightrope. That's the struggle. Is what's more important.
Can I respond to that?
Sure.
I believe that we may have a very different understanding of what the intention of this language is, because I believe that this would allow a person who enters into an NDA to keep that. It would not, they would still have the ability to prevent not the disclosure, that it's initiated by the employee, so they wouldn't have to initiate that activity that would void the agreement. And if that's not clear, again, I think that's something we can clarify. But I don't disagree with you where an individual enters into a non-disclosure agreement and wants to continue to make sure that that what occurred is not made public, that is still within the control of the person who entered the agreement, the employee. Go ahead.
Thank you very much. Madam Chairman, the bill respectfully doesn't read that way. It defines what a prohibited NDA is in the bill. It doesn't leave any choice or opportunity for either the employer or the employee to decide. It describes what a prohibited non-disclosure or non-disparagement agreement is, as you pointed out a little while ago. And I think that's what the whole bill is. I mean, right now, NDAs exist because employers and employees enter into them of their own free will. And that happens at the start of employment or an after separation agreement. Those only happen because the parties want them to, which is, for me, why I don't understand why this is before us, because we're effectively taking what happens in the real world by nature. I had this exact same conversation in the Housing Committee the other day. Things happen in nature for a reason. There's a reason why lease agreements have an expiration date. It's because when people meet up and they work on the terms of their arrangement, that's part of the conversation. Same thing with an employee-employee arrangement. Like, okay, well, how much is my pay? When do I get paid? What are the benefits? You know, that's what people work out on their own. They don't need us making laws to cover those things. That's what free people do of their own accord when they're entering into business relationships. And we should be careful when we're taking away the freedom of those parties to decide what those terms are. And I get the fact that the majority feels that there are certain places where the government has a role to step in. I would agree that there are some places, you know, when it comes to the safety of minors, for example, we shouldn't be putting kids in coal mines, et cetera, and we should have protections for that. But I'm a little more loath, I think, to say you should not enter into a voluntary agreement of your own choosing, like this bill says. The fact is that people who are in the middle of some element of turmoil at the separation of employment have to make choices sometimes, and they may be difficult choices. But ultimately, at the end of the day, they're their choices. They can either report criminal behavior to a police department or some other authorities. They have the power to do that now. And people sometimes choose to do that. Sometimes the employer will suggest that there's an alternative. Sometimes the employee will suggest that there's an alternative. Taking away those opportunities from the parties to come up with what they think is the best solution, to me, is the problem. Now, I mean, there is a subject of coercion, which I also have another concern about. I would not want to see an employer coerce an employee into signing an NDA. That's a different thing altogether. I have no problem working on legislation to prevent that in particular. I'm more concerned about the case where the employee really wants the thing. They're the ones that want the NDA, either because they're the ones that actually have something to lose because it was their behavior that would be protected, or because they simply would much rather get a check than be dragged through the press or some other situation that they don't feel gives them the proper justification, or it's not going to make the situation better. What happened, and having it publicly known doesn't make it better. Retroactively voiding contracts in this bill, I'm just going to kind of sum up just so we can get to that. But I have an amendment I want to offer that I think might help us get to a better place. I don't know if you will agree, but we will try that in a moment. Because the bill goes pretty far in some areas, retroactively voiding contracts, as we just described, I think it undermines certainty for a lot of businesses. There are some very large corporations out there that have thousands of employees. They may have, God knows how many non-disclosure agreements that are out in the world, you know, and if you write a policy that voids those contracts, that's a lot of uncertainty for a business, and it's an exposure, which I don't know is a smart thing to do. Again, we're trying to make Connecticut a more attractive place to operate and do business. Sending a message to the business community that if you come to Connecticut and move your large corporation here, that the legislature might just on a random Thursday in March, decide that the contracts that you've entered into for the last 25 years don't matter anymore? I think that's really like a scary message to send to business and industry. And ultimately, I'll just wrap up by saying the employee choice is the major concern. A worker might prefer a private settlement. They might prefer compensation. They might prefer confidentiality. The bill eliminates those things. So, Madam Chairman, I do have an amendment. I think that there's been copies handed to the clerk. Can we hand them out maybe, or does everybody have them? Okay. So I would like to move adoption of an amendment, and it's very straightforward. It's a single, it's done twice because of the two parts of the bill, but it's very, very straightforward. This is notwithstanding language. It says, notwithstanding the provisions of the section preceding it on line 316, any prospective current or former employee or independent contractor maintains the right to enter into an agreement containing a non-disclosure or non-disparagement provision at the discretion of such prospective current or former employee or independent contractor. All it does is it says everything else in the bill can stay, but the employee doesn't lose their choice. If they want it, they can have it. And the same thing after line 399, just to be conforming with the rest of it, does the same exact language more or less. It's a little shorter version, but it says, notwithstanding the provisions of the section, any employer or volunteer maintains the right to enter an agreement containing a non-disclosure or non-disparagement provision at the discretion of such employee or volunteer. I move adoption, and I'd like a roll call vote.
Thank you. We'll take a moment to review the language, so we'll go on pause. We're going to recess this meeting for 10 minutes so we can review the amendment. Thank you. Okay, we're back on the record. I don't know if that was 10 minutes because I didn't pay attention, but we're back on the record. And thank you, Senator Sampson, for giving us a moment to look at your proposed amendment. I looked at it and I do think that there is some room for agreement here on the fact that we think an employee should be able to enter into a non-disclosure agreement and shouldn't be prohibited from doing that. However, we also believe that there's nothing that you cannot restrict a person through any kind of agreement for contracting away their legal rights or something that is illegal activity that has happened. They still have the right to pursue that, to remedy it through the courts. They can't sign away their rights. I think this is, I think that we're not that far apart in our agreement if we're concerned about an employee having the ability to enter into a non-disclosure act, but we do want to be clear in the law that there are non-disclosure agreements that are illegal. They are prohibited. They are voided if they cover up illegal activity. So we're going to vote no today on this amendment, but I think we can continue talking about it. Maybe we can find a way to construct language that we ultimately could agree on.
Unless you wanted me to say something else.
You don't need to. With that, I will ask the clerk to call the roll.
A roll call vote has been requested on Amendment A to Senate Bill 355. Senator Kushner,
No.
Representative Sanchez. No. Senator Cabrera, Representative Wilson,
No.
Senator Sampson,
Sampson is yes.
Representative Weir,
Yes.
Representative Hall, Representative Hughes,
No.
Senator Lesser, Representative Canino,
Yes.
Representative Gauthier,
No.
Representative Mastro Francesco,
Yes.
Representative Shake.
No.
Thank you, Madam Chair.
Thank you. Back, moving on. Are there any other comments or questions? Senator Sampson.
Thank you very much, Madam Chairman. I appreciate the desire to continue this conversation and to work on the bill. I thought the amendment couldn't be more clear, frankly. I thought it was interesting that you mentioned the
Sorry. Excuse me one moment. LCO does point out on amendments, we have to call the roll and then announce the tally and close the vote on amendments. So, Mr. Clerk, will you announce the tally?
The tally is as follows: 4 votes yea, 6 votes nay.
Thank you, Mr. Clerk. Proceed.
Thank you very much, Madam Chairman. As I was saying, I appreciate the comments that you made about desiring to work on this bill going forward, and I will take you at your word for that. I just am compelled as a member of the minority who works very, very hard to try and make sure that we are knowledgeable about the bills that are before us, that we are reading through them in great detail, that we are understanding what is happening, that we don't offer an amendment like that casually. It's a desire to fix the policy. I tried to make it as narrow and clear as possible, and I'm disappointed to see what I think it failed on a party line. You mentioned the idea of people giving up their rights. I'm fighting for the same thing. The amendment says that the employee maintains the right to enter into an agreement. That's what the amendment was. I'm the one fighting for the right of the employee in this particular case. People sign agreements and give up their rights all the time, actually, but that's okay if they do it voluntarily. You know, when you take a job and you say, I'm going to go to work 9 to 5, Monday through Friday, well, guess what? You give up your right to stay home and watch The View. You know, you don't get to do that anymore. You've got to go to work. People make choices about what matters to them, and sometimes people will give up their right in exchange for something else, compensation. And having a right and exercising it are not the same thing. People are not necessarily giving up their rights when they give up their desire to exercise them in exchange for compensation. I want to preserve their right to enter into this agreement if they choose.
Can I
Sure.
respond briefly? And we don't usually have this kind of dialogue, but I think that there are some things that you've said this morning that we both take each other on our word. And when you say that you are concerned about coercion and you don't want to see coercive behavior where someone is coerced into signing an agreement, I think that's what gives me pause with your amendment. Will it open up an opportunity for more coercion? Having said that, I've been very clear that if there is a way to come to an agreement on an amendment that clarifies that a person can enter into a non-disclosure act agreement, then we can pursue that. I just think we need to take a little more time to make sure that we're careful in the drafting. I am not suggesting that you weren't careful in it, but I think we need to be careful in what we understand it to mean. I do think there is a conflict here, though, as well, that we're trying to get around. First of all, we know that someone can't right away in any kind of agreement their right to pursue a claim in court for a violation of the law. So a non-disparagement agreement or a non-disclosure agreement, you can't, neither party can enter in it in a way that the person then can't pursue their legal rights under the law. However, I think that what we're dealing with is a little, this is a difficult thing to get at because there's another public good that we're seeking to resolve, which is we do want to stop that kind of behavior in the workplace. And it might require that illegal activity that you can no longer enter into an agreement, a non-disclosure agreement, that would prevent the public or for individuals to know about that illegal activity in the workplace. And that's what gets a little dicey because clearly, I think we agree, we don't want this to go on. We don't want this behavior to exist in our workplaces. But we're both trying to figure out a way that we can write a law that makes it clear that that activity is no longer protected, that non-disclosure agreements, non-disparagement agreements no longer protect that kind of activity in a workplace. And I think that's what's difficult. We're trying to get at it in this piece of legislation. And I think we are open to continued conversation if there's a better way to draft it. But ultimately, we may not agree on how important, we might not be able to find an agreement that will allow us to move forward because we may have different goals. We may approach this a little bit differently.
Thank you very much. Madam Chairman, I appreciate the dialogue and the comments that you're making. I just struggle because I'm not operating off of what you're saying. I'm operating off what the bill says. And those are not exactly the same things. You're referring to whether or not criminal activity is being barred from being included in an NDA, but the bill doesn't say that. The bill talks about what the employee reasonably believes to be impermissible behavior, and then it describes some things that could be criminal behavior. But like, what if an employee steals from their employer? The employer catches them, and then they try and, in an effort to prevent that from being disclosed because the employee doesn't want to have their reputation tarnished when they go into the world to look for another job, they agree to, give back the money and maybe some other, benefit or something that the employee had or employer had provided them. This bill prevents that. Based on your comments, let alone the bill, that's criminal behavior. Guess what? Now the criminal behavior is now something that we can't hide. And therefore, even though the employer doesn't want to prosecute, the employee doesn't want to be prosecuted, guess what? They're going to have to. And it's all is a direct result of the desire that this legislation is very clear on to deny the freedom to make those choices individually. And again, as I said, on the coercion issue, if we were going to write a bill specific to prohibiting coercion and creating a very significant penalty for an employer that coerced an employee into signing an NDA, then I'm with you 100%. Let's do it. But that's not what this is. This is all about prohibiting parties from entering into NDAs. And I get the goal of the committee's leadership and the proponents of this bill is not about harming employees. I'm just saying that that is a direct consequence of the language that you have. And I tried to fix it. If you don't want to fix it, that's up to you. But note that I'm not going to vote for a bill that actually harms the employee. The NDAs often help the victim in a case when they are the victim. I just described a case where the employer's the victim, but in a case that you guys are focused on where the employee is the victim, sometimes the employee benefits from the NDA. You know, they don't want the public attention. They want privacy. They want a faster resolution. They don't want to have things tied up in court for a long period of time. They might want to move on from this set of circumstances. In my view, that trumps everything. Their freedom to decide that is what matters. And that's why the amendment that I had drafted, and again, I don't mean to keep hashing over an amendment we've already offered and failed, but the purpose of that was to make it as simple, cut and dry as possible. The employees should have the right to decide for themselves, and notwithstanding everything else in the bill, let's keep that right. And that's why I did it that way, because I thought I could make it as clear, black and white for you guys as possible to say, yeah, you're right. You know what? No matter whatever else we agree on, they should still have that right. I don't know that that even fixes the bill entirely. I think the bill has a lot of other problems. You know, I mentioned the reasonably believes language, even legally impermissible. That's other, you know, lawyer, language that makes lawyers rich, basically, because it's not objective enough to make a clear standard. The penalties that are in here, the empowering of CHRO, I think there's a chilling effect on business, as I mentioned. So again, I would support the bill under if the amendment had passed. I would have gladly done that. And I'm telling you that for the record, so that as we move forward, you understand fully that that's the make or break deal for me. And preserving the employee's right to decide whether they want to enter into the agreement or not. To me, that's what matters more than anything else. And I'm really upset that I can't support a bill that I know does help people in some ways, but it also has the potential to harm others in very significant ways too. And I feel terrible because people came to us and asked us for help, and I think we have the ability to give it to them, but we've got to do it right. We can't do it in a way that creates other unintended consequences. So I'll be a no today, Madam Chairman. Thank you.
Thank you. And I do appreciate the discussion we've had here today, and I hope that we can continue working on it, because it would be, I think it would be incredible if we could pass something that we agree on, would help protect those people that we've heard from, because their stories were very compelling.
I agree.
Representative Hughes.
Thank you, Madam Chair. I just wanted to level set a little bit about some of the discussion that we've had around a lot of, virtually no employee goes into a work setting and says, well, in case I get assaulted at work, I should probably have a lawyer look at this NDA that I'm expected to sign upon, upon a job offer. I think that nobody goes into a workplace thinking that some of the most egregious criminal and life-destroying behaviors are going to happen to them. So I respect the idea that this is an individual choice, but when we're talking about something that prospectively we have no idea what the risks are, I think that is a little presumptive, because some of these behaviors have been going on for years in some of these biggest employers. So, and that is because there has been no accountability and because the employee has the least power. So I think that this bill is trying to really open up a window on what a lot of survivors have had to carry with them in silence. I would like to also say there is no financial compensation that makes people whole after some of the abuse that they've encountered in these workplaces. There is no financial benefit that can even begin to address that. Third, that no victim survivor wants to be in front of a court. So the idea that this is a boon for a litigator, you ask any of our survivors if they reported this criminal behavior to police, and 9 out of 10 will say no. And that's because the system is rigged to just blame and further traumatize survivors rather than support them. That's the way our system defaults to, and every survivor knows that. So as we try to look at the actual experience of what is reasonable, I think we have to take into account the systematic, casual, complicit systems of abuse that have been allowed to thrive in silence and been protected through these NDAs. And that is why we are being very specific that they're unenforceable, to give survivors and their counterparts that come after them an expectation that this will no longer be not only tolerated, but expected, that everyone will be silenced by perpetrators that are allowed to advance, and employees that often try to leave for their own mental health and survival benefit, but they cannot pursue justice. And quite frankly, they will never be whole again. And I think that the amount of harm that is done to these workers is why we have to be so prospective about about legislation to protect them. And I think this does that. I also think it's reasonable to make sure that employees have an understanding of what that choice is, and to maybe narrowly craft language that still allows them to enter into an agreement excluding the criminal behavior, and to protect both parties. But I also would recommend that that person really review that with a lawyer, which a lot of employees may not have access to. Thank you, Madam Chair.
Thank you. Any other comments or Representative Weir?
Thank you, Madam Chair, and my colleague. I listened to Representative Hughes down the table, and also the thoughtful comments from Senator Sampson. Madam Chair, we've heard about obviously wanting to give the victim the choice, or the proposed victim the choice to enter into that agreement. We don't want to take that choice away. But as this, if all these agreements are null and void, where does this ultimately get adjudicated? If the proposed victim doesn't have the opportunity to move on, to be perhaps compensated, or to enter into one of these agreements and have it they may be the one who wants to have it enforced. What other recourse do they have? What's the next step if these are voided?
So I don't know if I'm going to be answering your question, but I do think in this legislation we distinguish between agreements that were signed at the outset of employment or during employment. We distinguish that from agreements that were signed on separation. And I think that what we're seeking to do on the separation agreements, which I think is where we're having the most discussion, I think that what we're seeking to do is to make sure that if an individual who signed a non-disclosure agreement separates from the company, signed on separation, that then they tell someone what happened. And then they get sued by that employer for breaking the non-disclosure agreement, that they would have the ability to defend their position, prove in a court that that non-disclosure agreement was prohibited and now void, they would only be able to recover their legal costs. So what we're doing in this bill is giving someone who has a belief that the agreement that they signed was a prohibited agreement, that it should have been voided. Now they're being sued by their employer for disclosing what happened. In that case, they would be able to recover attorney's fees. And I think that's a distinction. I mean, it's not something we have talked about, but I think that distinction is important to note.
And thank you for that explanation. And I guess where I'm going with this, and you didn't say this, I'm going to respond to Representative Hughes if I may, but that part of the concern with the victim is having to report this and go to the police or have this end up in a court setting. But this bill doesn't do that. This takes away the ability to keep it private, and the only way that they're going to be compensated is by coming forward and making this a potentially public. That's the way I read it. That is the argument that I heard. I'm not trying to, I want to make sure that we get this right, because if this goes out of the building like this and we're wrong, that's going to be the victim's only opportunity is to report it to the police, which they already have to do. None of this, you talk about sexual assault, physical assault, embezzlement, these excuse me, I want to make sure legally impermissible is another word for illegal. And these are illegal activities which are not permitted by law. So these are not, none of those would be covered under a non-disclosure agreement for an employee coming forward and looking to seek those out criminally. That's what whistleblower protections are for. And I don't believe that any NDA today that exists would be, if an employee came forward with a whistleblower type allegation, they're protected even when they're under the terms of an NDA. So I want to make sure that, to Senator Sampson's point, I think that everybody on this at this table wants to make sure that whatever comes out of this legislation, that we don't force the claimed victim to now have to make it a public spectacle in order to seek redress.
Thank you. Seeing no other hands, I will ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 2, Senate Bill 355, an act concerning limitations on the use of non-disclosure agreements. This is a motion to JF to the floor. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson.
Yes.
Senator Sampson.
Sampson's no.
Representative Weir.
No.
Representative Hall. Representative Hall, if you can unmute yourself.
Representative Hall, we're seeing your feet. Oh, there you go.
Representative Hall says yes.
Thank you. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Canino.
No.
Representative Gauthier.
Yes.
Representative Mastro Francesco.
No.
Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you, and the votes will be held open. Moving on to item number, if I find my agenda, I believe it's item number 3. Here, I crossed them off, yeah. Item number 3 on the agenda, Senate Bill number 356, an act concerning electronic filing of certified payroll and daily logs for certain public works projects. This is a JFS to the floor, and I want to provide the LCO number. It is different than what is on the published agenda. There was another change made. The S language is contained in LCO number 3177. Is there a motion? It's been moved and seconded. Any discussion? Representative Weir.
Madam Chair, we heard the testimony on this last week, and I think, I don't think many would argue on the fact that, reducing paperwork, certainly the safety side of things was what was really compelling to me, that knowing which employees are on the job site, should an emergency occur, having current, accurate data on who's on the job site to, if somebody's unaccounted for. That piece was very compelling to me and of interest, going to lead towards my support. But the piece that I am hung up on and continue to be, because I don't believe it's addressed in the language of the bill, and I look forward to if somebody wants to correct me. But the Department of Labor did testify that they have an interest in this, but they were looking for continued dialogue because they didn't have the answer on how this is going to be integrated, and that there is a significant price tag attached to this. So, Madam Chair, will this be heading to appropriations? Should it be passed out of committee?
Thank you. We're JFSing this to the floor, but I believe that in screening it will probably end up going at some point to appropriations. I do want to acknowledge that part of the reason why the S language was so late in coming is some of those discussions were happening with the Department of Labor, and the S language pushes out the date for implementation of those certified payroll portal that would be created till December 1st, 2028, precisely for the reasons that, they really needed to be consulted and worked with in terms of when that would be doable. And so I'm sure there will be a fiscal note attached, but I don't think, we don't have it at this time. So thank you for your question. Any other questions or comments? Seeing no hands, I'll ask the clerk to take the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 3, Senate Bill 356, an act concerning electronic filing of certified payroll and daily logs for certain public works projects. This is a motion to JFS to the floor. The relevant LCO is 3177. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson.
Yes.
Senator Sampson.
Sampson is no.
Representative Weir.
No.
Representative Hall.
Representative Hall is yes.
Representative Hughes.
Yes.
Senator Lesser. Representative Canino.
No.
Representative Gauthier.
Yes.
Representative Mastro Francesco.
No.
Representative Shake.
Yes.
Thank you, Madam Chair.
Excuse me. We will be holding votes open. So I'll move on to item number 4 on the agenda, Senate Bill number 436, an act concerning advance notice of an employee's work schedule by an employer. And it's a JF to the floor.
Second.
It's been moved and seconded. Representative Weir.
Thank you, Madam Chair. And we've seen this bill before. I remember, I don't know that it was here last year, but certainly the year before. Had some comments as it pertained to food establishments. And as I read through the bill, I'm gonna definitely take some time to go through it. It's only 10 pages, but it is pretty broad. And as I observe, it includes a lot more, many more industries than we've seen in the past. And so I want to make sure that we, as a group, understand what, how far-reaching this is. It talks, what I recall from the past was retail establishment, hospitality, food services, and even perhaps long-term health care, and the 500 and more employees. I got that number. Madam Chair, how did the number 500, how was this bill, how do we end up with the number 500?
Thank you for that question. Let me address something else you said, though. This is the same bill. We had all of these, occupations in the last bill that we took up. So it is, we didn't change anything in it. And it's identical. And the 500 was a number that we came at when we were working through the chambers and trying to reach an agreement on this bill. We knew that we heard arguments about smaller employers and their difficulty in addressing this. In an effort to compromise, we went to the 500 employee threshold.
Thank you for that, and I philosophically have a hard time putting these restrictions on any class of employer, excuse me. When I feel that, however, we focus on the 500 or more, the vast majority of our businesses are small businesses and small employers. It just seems like we've arrived at a number that's not going to achieve, if we are looking after workers in this, if the goal is to look after workers and to support workers rather than be punitive to business, the vast majority of businesses are small business, and we have excluded an entire class of employees to compromise at this 500. I think if it's good policy, it's good for all. And if it's not good policy and we have to pick a number in order to get consensus, I think that tells me what I need to know, that this isn't great policy.
I do want to just say that when we arrived at that number, it wasn't just picked out of thin air. I think there were some arguments made in our previous debates about the size of an employer that would be able to accommodate some of the scheduling software that was required to actually implement this policy. So I don't think it was just picked out of thin air, but there was some thinking that went into that. And there were some disagreements, and so, as you know, in the process, we try and find a point at which we can move something forward, even though, there could be a debate. Well, does an employer with 250 employees have enough resources to have that kind of scheduling software, or is it a 500? And rather than have a debate, it seemed like an area of compromise. So I just wanted to make sure you understood sort of where we were coming from on that. Thank you.
And thank you for that. I realized I had something printed out that didn't make it down here with me, so thank goodness for
Take your time.
having the laptop here.
We're being really relaxed today. I know I'm being relaxed. I don't know if that's working for you,
This is
but
a relaxed setting, I think it should be relaxed. We should be able to have great discussion. So I'm appreciative of that. These are not relaxed topics. These are this is policy that we're looking to create. I think we should be slow and deliberate and having these good discussions. So I appreciate that. So, retail establishment, hospitality, long-term health care services established, food services establishment, that 500 or more globally and 30 more locations within the United States or globally. Franchisee, food establishment. So within the food establishment NAICS codes, you got special food services, drinking places, which I imagine are bars, and then you've got restaurants and other eating places. Madam Chair, so there's 3 different NAICS codes within a classification of 722. What differentiates a special food services from a restaurant and other eating places, if you know? Excuse me, 21 through 23. And I had my notes, and maybe I'll try to look it up here.
this dry air is killing me. I believe that the use of these, so we've learned a little bit more about the NAICS codes, and they are voluntary, so that an employer chooses a code that they use. We use them in legislation to try and help guide us, but I don't think that it is more the definition than how somebody is actually, whether or not they identify themselves with that. I think special, I could assume that special, the term you used was special food establishments, is that right?
Special food services, and
Special food services. I could assume that that could relate to a caterer versus a sit-down restaurant, but I'm not, I'm just assuming that. I don't have definition, perhaps we could stop for a moment. I could check in with our OLR.
Sure, and I actually brought it up here, so if you'll indulge me being able
Sure.
to do this,
Go ahead.
maybe this can be a work together. I had printouts that I left up in my office. So, special food services, for clarity, you were correct, catering, and it appears mobile food services, so I'm going to assume that's like a food truck, and it says it covers non-traditional food services that do not operate as conventional fixed location restaurants. So, food trucks and catering. I think that's fair. Drinking places, to me, looks like it's a bar, which I believe I looked up last night, and that was the case. And then the last one was restaurants and other eating places. And that's the general catch-all for restaurants. Meals, snacks, and beverages for immediate on or off premises consumption. So, eat in, take out, buffets, that sort of thing. So I'm not trying to bore everybody to death. I know we're saying relax. I don't want to put people to sleep. But I want to understand that we're talking about, I'm not sure of a global catering establishment. I imagine this could be, I don't know if that would be like a cafeteria style. No, but this is on the move. At any rate, we're picking up all the food and drink establishments. Hospitality, hotels, and casino hotels as defined also, so 721120. Forgive me here. Yeah, so casino hotels. So through you, Madam Chair, do you know if that would include the two casinos that we have here in Connecticut? Would they be subject to this law?
I believe so, but let me check.
I know, that's why I asked. Well, it says right here, casino hotels. It says it right here. Yeah, so, when Kathy asked them. I don't think so, but. Says.
Thank you. This is a complicated question you raise because it does overlap with tribal sovereignty and laws that protect our tribes. In the area of some labor law, there have been decisions that would apply labor law to the casinos. I happen to have brought one of those cases, so it's very clear to me, but those were very circumstances that were established by the National Labor Relations Board. Here, I believe it would be determined either by the AG or the DOL whether it would apply, and I don't want to presume that it would automatically apply to the casinos because they are tribally owned casinos. And so I don't think we can give you a definitive answer on that, but I'm sure we may hear from the casinos about it, or the tribes in that case.
Okay. Yeah, I don't recall hearing their testimony.
I don't think I don't remember hearing
on this
any
at all.
testimony.
This caught my eye. And so, they are two of the biggest employers we have in southeastern Connecticut. And if it doesn't apply just to them, you have space at the casinos where establishments lease, rent, operate out of those casinos that, so I think the same question would apply is if P.F. Chang's or Michael Jordan Steakhouse, who may have, two off the top of my head, who may have more than 500 people globally, are they in, or are they covered by this or exempt from this as a result of being in the casino, or are they included because they're not part of the tribal nation? And I think these are questions that I have reading the bill.
Thank you for that question. I'm sure we can resolve. I think that one's a little easier to resolve because it's not owned by the tribe. It is something that is operated on a lease basis. I think it would be easier probably to get an answer to that, but I don't have it for you today.
Okay, and thank you, Madam Chair. Senator Sampson pointed out that this is this is important policy that we're looking to put out of this committee, and it's I went through last night and almost to the point of bedtime was going through this bill at the kitchen counter, and it's concerning to me that the answers aren't that this isn't the first year we're seeing this, and I'm not. There's a little frustration, but that we don't have these answers now as to who's in. Presumably this will pass out of committee today, and then it's going to go to the floor. And I think the time to be having these discussions is now, and maybe even before now, to ask these questions. I know there's always time to work on this stuff, but it's disappointing that we put in the time to understand these and we don't have the answer. Madam Chair, on lines 28 through 30, it talks about a long-term health care establishment, nursing care facilities. Is there a reason why we did not include, or why assisted living facilities were left out of this bill?
Give me one moment.
I have it if you want it. Okay.
We'll go back on the record. Representative Weir, I think that the long-term assisted care facilities without nursing care there are included under that code that is referenced. So thank you for the question.
Okay, thank you. And it appears that there is another code for assisted living completely separate that also covers assisted living. So I want that on the record that, there are multiple codes for presumably the same category.
Thank you. That is so noted.
I would like to just go to lines 49 through 51 under retail establishment. And the category for the NAICS codes are sections 44 to 45. And I just want to be clear, some of what is considered a retail establishment under section 44 would be motor vehicle and parts dealers. So your Napa and your, as I see it, Advanced Auto Parts, probably not, Joe's Corner Auto Parts Store, presuming Joe doesn't have 500 employees. But these are motor vehicle and parts dealers. That could be your local Ford, in my, just outside of my district, we have a Ford dealership. And so if you've got a dealership that operates multiple locations and may have more than 500 employees, we're talking about car dealers and auto parts dealers in our districts. Furniture and home furnishing stores, electronics and appliance stores, building material and garden equipment suppliers, dealers, food and beverage stores, grocery stores, specialty food, beer, and wine, health and personal care, so that's your CVS and Walgreens would all be under this category. Gas stations, clothing and clothing accessory stores, so again, retail, furniture, home furnishings, electronics, appliance retailers. So if you can think of and that's also new and used car dealerships if I bounce back. Convenience stores, pharmacy and drug stores under 44. And so when we debated this in the past, I think I'll admit that it may have been lost on me, the level of detail and the number of, I certainly opposed it in what I thought was more limited to food and beverage, restaurants, hospitality. To me, that was a stretch to ask that of our businesses. But now you look at all these other industries that it encompasses. Like I said, I have a Ford dealership just outside my district, and I know I'm included in a lot of the discussions when they have a concern. They include oftentimes me in with the other, with the state rep who has that in the geographic boundary. And it's concerning to me that, this potential dealership or a lot of these stores that, they're going to be in our districts. And I think we ought to be able to answer and be prepared to answer potentially, if this passes through committee, why we're going to be putting another set of restrictions on the scheduling. Madam Chair, so in section 2, lines 55 through 61, talks about prior to the start of employment, an employer shall obtain a written statement from a new employee. Is in your estimation, or is there, what forms of a written statement are acceptable? Do we have an idea of what's expected, what constitutes a written statement?
I think there are no parameters put on this beyond the fact that it's in writing. Obviously, that could include an electronic form that they would fill out or a handwritten form that they fill out. I don't think that really is left to the employer to create the format for employees to advise in writing the times, the days and times that the employee is available to work, and their desired number scheduled work hours.
Thank you for that. We'll also note that a lot, throughout this bill, there's a lot of, shalls and mays. And, those two are different. Shall means must. May, as we know, is optional, can be optional. And a lot of the language that's geared towards the employers has a shall. There are very few, if any, mays that the employer may. On the opposite side of the coin to that is the employee side, where there's a lot of may, and it's a lot of it's very permissive, and it just seems to me that we don't allow these. We often we put demands on the employers, and we often assume an adversarial relationship between the employee and the employer, when in truth, most of the time, they're working it out to solve the problems if there's a scheduling issue. I have 3 daughters. I know that I've worked myself. All 3 of them right now are working in local establishments where it's shift work, where they're called in, and sometimes they're called in to fill a busy shift. Other times they're sent home when work is slow, and they work it out with the employer. I know that I've been subject to that. Worked in different industries in my younger days, subject to the demand of the customer. And if there's no work, sometimes you get sent home. If there's extra work, sometimes you're working extra hours, and you're meeting the expectations to meet the demand of the customer. In Section 2, subsection B, where it talks about the obligation of the employer, what is a good faith written estimate of the employee's anticipated work? Is that a best guess? Is that a historical? I think we understand what the term kind of, but what is this in this legislation? What is the intent of good faith?
I think the intent is that oftentimes when a person is employed, and we're really talking often in these cases of part-time employees or shift employees, that an employer will often say to the new hire, I'm hiring you for 25 hours a week. And then the person takes the job, and they are either required to more than that, or more frequently much less than that. And so it's very hard for that part-time employee who has maybe given up another opportunity somewhere else to, it's hard on that employee. So I think here we are looking at once that there's a written statement like that, then there's an expectation that hopefully will be more fulfilled on the part of the employer, by the employer.
And so is there a range? I know it says average number of hours in an average week, but is there, is good faith if the employer says, and again, this is all hypothetical, I have 25 hours for you, and then that number turns out to be 20 or 15 or 23, is there a range with which a percentage that when that falls within the intent of this bill, where we're not going to be, I guess, who decides at the end of the day if the employee has an issue and says, hey, you told me 25, it's 23, versus you told me 25 and it's 10, I'm trying to figure out who ultimately will make the decision whether the employer acted in good faith in that estimate.
Yeah, I think if you go further down, it says that an employer shall not be in violation of this section if an employee's scheduled hours for any given week exceed the average number of hours provided in the written estimate, provided they made a good faith effort. And I think, or every effort in one case it says. So I think that this is really built in to assure that someone is able, and a new employee, when they take the job, is able to know what's expected of them, and know also what they can expect from the employer. So I think that there's an effort to reflect there that in order for this to be seen as a violation, there would probably have to be a consistent practice for weeks where, not an occasional occurrence.
Okay, thank you for that. And I see in those lines that you cited to me were roughly 69 through 73, which talks about, addresses if the hours exceed the estimate. But what is who decides, is that if it turns out that the employer said, I'm going to need you for 25 hours, turns out they only need, the employee is only getting 20. Who will decide if that employer acted in good faith, if they underestimated, or if they overestimated the time needed, but the employee is not, your example covered more hours than estimated. What happens if it's less?
I think if you look at the sentence before that, starting on 67, there's some flexibility written in for the employer. Says they shall revise such estimate when there's a significant change in either the employee's availability or the employer's business needs. So I think that is written, there is an understanding that that could change. This isn't prohibiting, it's not setting a strict rule that they have to adhere to, but I think it's designed to make sure that there's a better understanding between the employer and the employee of what to expect. Now, even understanding that that could change.
I thank you for that, and I appreciate the intent. I think that as an employer, it was good practice for me to set those expectations, because last thing I want is an employee coming aboard, leaving another opportunity, as you stated, and then arriving and then finding out after 2-3 weeks of onboarding and training and getting the person, it takes a lot of effort and work, not just on the part of the employee, but also the employer to integrate that person into the company. A lot of training goes on, and so I would completely agree that it's a good practice. I'm concerned with the fact that we're legislating it here. We're setting that set of parameters that the employer must. When a few lines later, we talk about the fact that the estimate can be adjusted. And if it's more hours, then there's no violation. You can't, if you promise 25 and you delivered 40 hours, this bill doesn't address that in terms of that's not a violation. The next page, I know you did say that electronic means is email. Well, actually, no, this says electronic means. So is that text messages or email in your estimation, line 79, in terms of how the work schedule must be posted?
I believe it would include either.
Okay. Yeah, I got to tell you this. If I read to you lines 79 through 85, I found this quite confusing. At least this was last night, after you read several pages of this. And again, for the people listening, and certainly for my colleagues, I'm certainly no attorney, and for a business owner or an employee, a prospective employee who are not attorneys, to try to have to go through the language that we put together, when it's not clear, and that you have to go to an attorney to translate and turn this into perhaps an employee handbook, it really puts a burden on everybody when the language that comes out of this building isn't clear. And so I'll just read the few lines and see if I have it right, and you can correct me if I have it wrong. It says, for a new employee, an employer shall provide such employee with the employee's initial work schedule not later than the date of the employee's first scheduled shift for the period commencing on the date of the employee's first scheduled shift and ending on the last day of the 7-day period covered by the latest posted or transmitted work schedule. I can't tell you how many times I had to read that last night to try to make that make sense. And the way I understand, that could have been said, summarized in, for the first 7 days of work. And we went through all those lines, which I believe could have summarized in the words, first 7 days of work. would have replaced what's there. I mean, reading it now, I'm glad I made notes, because today it doesn't make sense as I'm reading it. It's confusing. Senator Sampson pointed out, when we're not clear in here, an attorney's got to interpret this, or an employer and an employee may try to interpret it, and if they don't arrive at the same conclusion, now we've put them at odds with language that wasn't clear here. And you know, $450, $500 an hour. I was reading the other day in the Wall Street Journal that some of the attorneys now are upwards of $10,000 an hour. Now, I don't think that that's going to be in, you know, that's in the mergers and acquisitions world, but you know, to pay somebody several $100s an hour to try to put a piece of paper together to interpret what those 6 lines mean, yeah, I don't think we're doing people favors.
Representative Weir,
Yes,
I don't know if you were finished, because I know sometimes you take a pause.
I'm taking a pause. Go ahead.
But I do think that this is another example where we're talking about employers of a large size. We're not talking about small employers. And most frequently, they do have in-house counsel when you get to that level of employee, number of employees. But I also think this is an area of, you know, I think frequently we are looking at legislation from other states where they figured out how to make it work, and or cities. And I'm not convinced this is one of those cases, but if it may help bring some clarity if we look at that, or maybe we can simplify it. So I wouldn't be opposed to doing that to address your concerns.
And thank you for that. It certainly could be clear, and I would recognize that a larger firm would probably have more resources than a small. So thank you, small business. So thank you for making that clarification and reminding me. However, as we tend to do in this building, we start at a higher number and then work our way down. So 3 years from now, this could be, you know, somebody employing 11 or 25 or 11 or 1. You know, we've seen it happen, and so you know, we end up putting a lot of onus on. I think we strain the relationship between the employer and the employee out of this building, and we make assumptions. You know, because it's an imperfect world. Things happen, and I'll go through some examples later on as we get through some of the other pages. But I think things happen out in the real world where something, you know, a scheduling issue occurs, and the company and the employee need to adjust, and most of the time it may not be perfect and it may not be smooth, but they figure it out and they figure out how to make it work, because the ultimate goal is to service the customer, and the ultimate goal for the employee is to have a paycheck and to be able to support his or her family, or, you know, if it's a young person, you know, just getting into the work, they're looking to make some money, and the employer is looking to profit. And so, but you don't profit if you're not delivering a good service, and you don't have good employees, and you don't have customers who appreciate the service that's put forward, or the offering. So if you're not delivering that, you know, you end up without the customers. So a lot of times the employees and the employers are perfectly capable of solving this on their own. I talked about the mays versus the shall, lines 101 through 107. It talks about the employee being able to request, may be able to request in writing, that the employer add 1 or more regular on-call shifts. So if the employee wants more work, they can request more work. Perfectly fine, and that's something that could occur without legislation. So here is, starting on lines 108, we're on page 5. An employer shall provide the following compensation to an employee for each employer requested change that occurs to the employee's work schedule without adherence to the notice requirement in subsection B, which was 14. Go back to subsection B, excuse me. Subsection B. Yeah, 14 days prior to the first date of any work schedule. So the employer has 14 days, has to provide notice of a schedule 14 days in advance. So, Madam Chair, in lines 112 through 113, the employer has to pay the employee 1 hour of pay in addition to wages earned. How was that number, who decided on an hour of pay was fair, or how do we end up with 1 hour?
I think the 1 hour of pay was that there would be some incentive, but also I think it was considered not an overly burdensome amount of money.
Okay, and that was if they added, so you owe the employee an hour of pay, an extra hour on top of the regular pay, if the employer added 1 or more hours to the employee's regular or on-call shift within 14 days. Okay. If the employer changed the date, start time, or end time, or location of employee's regular or on-call shift without a reduction in hours, or schedules the employee for an additional regular or on-call shift. So, again, within 14 days, I'm not even sure if I agree, because a lot of times if the employer schedules the employee for an additional regular or on-call shift, I would think that when I worked police, the contract said that you didn't really have the option to refuse overtime when it was an emergency situation. And here, I don't see why the employee couldn't turn down working that shift if he or she was unavailable. I'm not sure why they have to accept it. It doesn't even say that the employee has to work it. It just says that if the employer adds 1 or more hours, changes the date, start, or end time, or schedules the employee for an additional regular or on-call shift. So if the employee simply said, I can't do it, I'm not sure why that employee would be obligated to work, or why they would be entitled to an hour of pay for the employer doing one of those 3 things. And then the next section, 2, they get a half of an hour's pay if the employer takes work away, subtracts hours from the employee's work shift. So if they add hours, the employee gets an extra hour. If they take hours away, they get a half hour. They get a half hour if the employer cancels the employee's regular shift, or if they change the date, start time or end time, or location, resulting in a loss of hours. So if there's more hours added to the employee, they pay an hour. If there's less time, they pay half an hour. Unless you get into section E, subsection 127 through 30, that starts dealing with the employee. I annotated it that the employee initiated actions. So 127 through 130, an employee mutually agrees with another employee to an employee-initiated shift swap or coverage. And then I guess at this point it reverts back to the employer policy on regarding shift swapping. And this is like a tongue twister, and I apologize for the monotone, but this is the language of this is pretty dry. Does not apply if the employer makes changes to an employee's work schedule at the employee's request. Does not apply if the employee's request to use sick leave, vacation leave, or other leave subject to the employer policy. And of course, we all know that the employer policy is now subject to the state policy on paid leave. So it's really the state policy. Does not apply if an employer's operations inability to begin or continue due to failure of a public utility. Madam Chair, what would be an example of a failure of a public utility?
I think that would an example of that would be when the lights are out at the mall, there's no power, so they couldn't start. But I want to point out something. I know you're going through all of this, but I don't want to, I hope we understand each other, or that my understanding of this is that when the employer says, I need you to come in, and you're working additional hours, you get that extra hour pay. The second part of this that you referenced, when it's subtracted, when 1/2 of employer's rate of pay per hour for each scheduled hour, that's line, let's see, where is that? That's 120 to 121.
Yep.
That's when a person comes into work and they say, oh, we don't have work for you. You actually have to give them half of their time, not just a half hour, but half of their time that they were scheduled for. And I think that the reason for this is that somebody had expectation of work. They were counting on that pay to pay their bills, or to pay their babysitter, or to pay the gas. And so there is an obligation on the employer when they cancel a shift like that to make some compensation. There are a lot of union contracts that require that. And I think this is applying more, you'll see, where there's, we're applying it to industries that don't necessarily typically have organized collective bargaining agreements. So I just thought, I wasn't sure you got that subtle distinction. One is in the case where the person's actually performing the work. They get an additional 1 hour for that shift, not 1 hour, it's not double time. And then when they cancel a shift, they're getting half their pay. That's the way
Okay.
I read it.
And it's not, so it's within the 24 hours, subsection B, or, so the subsection B that references back, is that lines 90 through 100? Or is that subsection B line 62 through, I think it's 90 through 100? 3, 4.
D. D is modifying section 3, right? All the language.
Yes, yeah.
Yeah.
So sub B, okay, 3 subsection B,
D, I was,
but D references at line 1, that's 3D, is line 108.
108, yep.
Then at line 111, it references 3B Bravo. And so, so is that saying that,
It's saying when they haven't given the 14 days notice. That's when this applies.
okay, so 14.
When they've made a change, essentially, but then,
Within 14 days. So, I mean, to me, that seems crazy that the employee is owed an hour of pay if they're not notified. If they have to be notified more than 14 days in advance if they gain hour. I understood it to be what you're saying.
okay.
And to me, that seems, yeah. I want to get back to okay, public utility, we talked about electricity. I guess that could also be if the water went out and the health department came and closed the place down. That's the failure of a public utility, a fire or flood or natural disaster. Now, just to be clear, does that mean at the location of the business? Right, I mean, we're assuming the business is closed because of a fire, flood, or natural disaster.
I'm assuming that in the case of multiple locations, it would only apply to the location where there was the failure to operate because of failure of the public utility or all of those other qualifiers.
Okay, so in the event of bad weather, if I think about, we had a blizzard. Before that, we've had several snowstorms this year, none of which I think would rise, certainly wouldn't classify as a flood, a fire, And I don't believe the governor called declared a natural disaster. So does this bill address the fact that you've got a snowy night, 8 inches of snow on a Friday night, nobody's going anywhere, and the business is closed? What happens then?
Then I think, then I think it would revert back to the previous section that we were talking about, where lines 118, where the employee would receive 1/2 of their regular pay for the scheduled time.
Okay, even though this was not at no fault of the employer. So if the employer cancels the shift because there's 8 inches of snow, we're going to make the employer responsible for paying for the hourly employees even though they never opened? That's the way you read it? The employer is responsible in the event of a snowstorm.
That is correct.
Wow. Madam Chair, in Section 4, line 141, that's where it begins. And really, I want to question, I don't have too much more here. Line 144 talks about 11 hours, the first 11 hours. So no employer shall schedule or require an employee to work during the follow rest periods. The first 11 hours following the end of the previous calendar's day, regular or on-call shift. How was 11 hours determined, if you know?
I believe that, well, my understanding is that we are creating a circumstance here where people have proper rest time in between shifts. And so they have this thing called clopenings, where you're scheduled to close and open with not enough time to get home and rest. And so the 11 hours is inserted here to protect and ensure that workers have the correct enough time to rest.
But then right down, it says that the employer can't schedule or require. Those are two different things as I read them. But then down in lines 148, it talks about that the employee can consent to working those hours. So how do we reconcile that if the employer can't schedule but the employee can consent? Doesn't say the employee has to request.
So I would respond to that by saying that this circumstance really goes back to what I've heard from you and your colleagues at times about wanting to give workers the freedom to do something. They are free to accept a shift that, or consent to work these hours, but there's an incentive in there because they would have to compensate at 1 1/2 times pay. So it does provide some incentive. These circumstances often exist in employment where an employer wants something from an employee that goes above and beyond what they normally would have the expectation to do, and they incentivize it by paying additional pay. And I think that's what that's getting at here.
And thank you for that answer. And I would agree. I have at times been on the receiving end of, at the employee and the employer end of both of these scenarios, none of which had a mandate with them, but where my services were needed and somebody was willing to pay extra for me to come in. And as an employer, I can guarantee you that I've had to incentivize employees to be available on call, on weekends, on holidays, because whether or not they agree to it, without the incentive, at some point, the incentive is certainly helpful. And when that person is saying, geez, I've worked 3 Saturdays in a row, they're able to justify it and say, yeah, but I received a bonus for being on call or for being available. And now I'm able to have that extra money to do stuff with my family that I wouldn't have otherwise had. That's just one example. However, the employee needs to, validate the reasons for him or her accepting those additional tasks. Incentives are why we do a lot of things, but I think that what this legislation does, among other things, the only way for an employer to not be subject to these extra pay requirements would be to have extra people on staff. Maybe unneeded people, maybe a lot of these companies operate on tight margins, and because profit is important to keep the doors open, they're not going to have an employee just sitting around. They're not going to have several employees. Maybe some will, but this almost mandates it. Some of these companies run lean operations because the margins and the dollars just are not there. And here we've added another requirement that's going to force them either to pay the employee, that we've taken away that opportunity for the employee and the employer to work it out, and we've mandated what the employer must pay. I'd like to jump down to section 5 where it talks about hiring a new employee, and as I read this, this would prohibit an employer from hiring a new employee without offering existing shifts to employees to make every effort to schedule such current employees for such current desired number of weekly hours. So the line above the section above, section 4, as I read it, is putting some pressure on an employer to have additional employees to cover the times when the employees are lean, or they have to incentivize those employees to stay. And then in section 5, it really discourages an employer from hiring a new employee without giving right of first refusal almost to the existing employees. So I'm not sure can you talk to section 5 about how that seems to be in conflict with section 4? Do you see it that way, or am I?
I don't really see it that way. I think that section 5 is, we are talking about shift work now. This bill is directed at people who are working either part-time or shifts that are constantly changing. But a lot of these are shift work where they're working part-time. And in this particular item, section number 5, we're looking at workers who have been hired part-time, fewer than full-time hours, but they've indicated to the employer they'd like to have more time. And in that scenario, the employer, where an employee has indicated that, the employer has to make every effort to give additional shifts to that person before going out and hiring another worker. And I think this is really designed to ensure that in an economy where we've unfortunately gone to a lot of part-time work, for the benefit of employers to make more money by hiring fewer people, or hiring people for fewer number of shifts, or hiring people that don't qualify for benefits. There's all kinds of reasons employers have done this, but this gives some protection to the employee who wants more work to get those hours before they hire another person from the outside.
Thank you for that answer, but it doesn't say part-time in section 5 that I see. There may be an assumption that, I think these are shift workers that we're talking about, but I don't know the percentage of part-time to full-time. This section 5 does not talk about part-time versus full-time that I see. It says, prior to hiring a new employee from an external applicant pool, including the use of a contractor or temporary help. So if the current group of employees, I think there's a reason why an employer would look to hire a new employee, and it's probably because their current employees are maxed out, or they have an inflexible schedule. The schedules aren't matching up. And here, says that the employer needs to give right of first refusal before hiring a new employee.
Representative Ware, I think we could probably address that. I think this is intended for part-time employment. I don't think we need to do that today, but I think we can continue talking about that.
Duly noted, that makes it, I'm not sure that that makes it better, because I think there's a reason why, I think there's a reason why employees work part-time. There's a reason why employees work full-time, and consequently why employers have a mix potentially of both. Because you may have periods of time during a workday that are busy, and it may not be an entire 8 hours. So you've got, I'll speak for my, at least one of my daughters now who's just getting into the workforce. She works at a pizza restaurant, and she's after school, so she would not be available full-time. But she sure appreciates those hours, weeknights and on the weekend. But that employer also has full-time staff, for those people who want to eat at a pizza restaurant at lunch hour, where the high school kids are not available. And we're,
Representative Ware, on that example, because just to stay on that example for a moment, there's nothing here that would require someone to, I agree with you, there are people who want to work part-time after school is a good example of that. This is really geared, I think the way it's written, it's geared toward the person who would like to work full-time, but there's no full-time work available in their community. So they're working part-time, let's say, at a restaurant, as you suggested, and now the owner of that restaurant, they've asked for more work in their written statement of the amount of hours they would like to have. And now that employer, instead of giving them the additional shift, goes and hires somebody else to work only one shift that week or 2 shifts that week, when that individual had indicated that they wanted more hours. I think that's what this is trying to address, and if it doesn't do that effectively, I think we can work on the language, but that's the problem we're trying to solve here.
yeah, it definitely, I appreciate your explanation of that. The bill doesn't read that way. And when you're talking about the written statement, was that earlier, the employee, if I get way back in the beginning, but you're talking about the written statement of desired hours earlier on that we spoke about? That was the written statement?
Yes, it references back to the written statement provided by the employee pursuant to Section 2 of this Act.
Okay, yep. Yeah, and so that's, upon hire, but things change.
I do believe in that section, both the employer is allowed to change, as well as the employee is advised that they have to give written indication. If they fail to do that, then I don't think there's an expectation that the employer should just know this person wants additional hours. So I think that there is a requirement that if they would have to have made that change and that request.
And I appreciate that. I think we'll go back to, and part of it is the philosophical belief that, and practical experience that employers and employees are perfectly capable of having those discussions and those conversations amongst themselves. There are oftentimes when I've seen, as an employer, had an employee who's performing, we've hired them perhaps part-time, and they're doing great. And it's like, hey, if you get extra hours, I really like what you're doing, I could use more of the hours. Or we've hired them full-time, and I think you're doing great. You're in a field as a carpenter. I would love to move you to a project manager because you're very organized, you're good with the customers, whatever. Those are conversations that happen all the time. Or, the person, you hire them for something and they're not as good as advertised, or they're not meeting the expectations, and you try to find a spot for them. Those conversations happen all the time without, a 10-page bill, and I don't know how long we've been here. I'm not trying to drag this out, but I'll tell you that this is going to end up in front of attorneys or a judge somewhere trying to make sense of this, or HR department with in-house legal counsel at, whatever, how many hundreds of dollars an hour to implement the requirements. And I think the system, for the most part, it's imperfect. It'll be imperfect after we pass this, out of JF. If this becomes law, life isn't perfect, and people are capable of working it out. Um, You know, 163 to 168, again, talks about the employer may hire individuals from an external applicant pool if such employers' current employees lack and cannot obtain with reasonable training the qualifications needed to perform the duties. I mean, again, that is the decision of the employer. Yes, in a perfect world, it's nice to have those discussions. You may have an employee who has all the skills in the world and they're just rude with the customers, or they're just terrible. And sometimes, you know, I admit to being this employer in the past. You don't want to maybe have some of those direct conversations to say you're just terrible with the customers. So, or whatever the person's shortcoming you know, at times in my life I shied away from having those direct conversations where you don't want to hurt the person's feelings. So you keep them where they are, and you get somebody else who you know is going to be a better fit. And this would say that now they have to try to put that person or justify why they're not through legislation. And a whole bunch of, you know, then in subsection C, we put a whole bunch of restrictions on the freedom and the ability for the customer to remain nimble, for the employer to remain nimble in trying to find the best use of the people and the best solution for the customer and the company. And we've boxed them in terms of the decisions that they have to make and when and with whom. You know, Section 6, I don't know which businesses are not keeping true and accurate records of employees' work schedules. The fact that we've mandated it, do we, Madam Chair, is there a reason why it was chosen period of 3 years that the employer has to maintain the work records?
I believe that was considered a reasonable amount of time and may actually conform with other requirements on businesses in maintaining records. I would have to check that, but
I would like to follow up on that because I don't know. I mean, I know there are certain, you know, certain records are kept for a certain amount of time, IRS records, financial records.
I think we could get an answer for that. I think if we go to DOL, they would probably advise us why that 3 hours works for them or doesn't work for them. I think we could look at that.
Okay. And so Section 7, I don't recall seeing testimony from the Labor Department on this. Did the Labor Commissioner testify on this bill that you're aware of?
Let me just check and make sure. I don't believe she testified, but she may have submitted written testimony, so
submitted
give me a
written
minute.
testimony, thank you.
We'll take a brief pause. Actually, at this point, maybe we should take a 10-minute pause, because I know I would appreciate a 10-minute break to use the restroom. And then we can come back to it. Is that okay with you? And that'll give me time to find out the answer to your question. Thank you. Okay, we're ready to go back on the record, and I believe Representative Weir reminded me that the question was whether or not the Labor Commissioner testified as to Section 7, and no, there was not testimony written or otherwise about Section 7 that we found.
Okay, thank you for that. I'd like to, hear, we have a, more or less a requirement of the Labor Department and the Labor Commissioner to adopt these regulations, and I'd like to hear what they have to say about it. Thank you for that. So Section 8 talks about, I guess, relief for an employee, an aggrieved employee can go to the Labor Commissioner, or the Labor Commissioner can file a complaint in the Superior Court to recover compensatory, so really penalties. I'm not an attorney, but it just seems to me that a lot of this could be solved currently in any other dispute between labor and management. Maybe not any other dispute, but in most, certainly as it is today, that employee would be able to go to the Labor Commissioner, make a complaint, have it adjudicated, and get get an answer as to whether or not the employer violated law. And I just think this is punitive. And Madam Chair, line 196 to 199. How do we get $200 per violation if an employer violates any of the provisions from Section 2 to 5? Page 8.
I'm sorry, what's the question?
How was the number of the amount of $200 per violation arrived at? Where did that come from?
I believe we were looking at taking into account other penalties and other legislation and arrived at 200 as a reasonable amount to assess.
Thank you for that answer. Staying further in that, I don't have any more questions. I'll give you a heads up, but we've got more and more penalties. This entire Section 8 is about penalties against the employer. Section 9 talks about a whistleblower on behalf of the state, and they can bring a civil action in Superior Court against a covered employer who violates the provisions, recover damages, civil penalties, equitable and injunctive relief, which is, this is really punitive. Today, this is telling me that we don't have confidence in our Labor Department in handling these situations as they come forward, that we need to automatically hit the nuclear button and put people in court, which costs money, takes a lot of time for both parties. Then after 30 days, the Attorney General can get involved with the permission of the court. Or so within 30 days, the AG can get involved. After 30 days, the AG may intervene with permission from the court. So now we've got civil penalties, we've got whistleblowers, got the Labor Department, injunctive relief, and now civil penalties and the Attorney General involved. That's great. Yeah, I'll just leave it at this, Madam Chair. No more questions. We've, as I stated from the opening and throughout, business and delivering a service or a product is imperfect. We don't live in a perfect world. There are in many cases where employees and employers work together in harmony to deliver a product or service, and there's other times that they don't, and that can be contentious. I think that's unfortunate, but it's reality. They're not, and sometimes the employer can say to the employer, "This isn't working out. Please find another place to work." And the employee can also say, "This isn't working out. I'm going to go find something else." And it's my contention that we take those relationships, which for the most part I would argue are not contentious. Doesn't mean they have to be in harmony 100% of the time, but I think that the employers and employees are capable of working things out more often than not, or moving on, which is okay in my opinion. And we take those relationships and we assume they're contentious. By putting in legislation like this, I think we make it more contentious. We pit them against each other. rather than letting them work it out. And I'm sure there are circumstances whereby employees are aggrieved, and there is an opportunity to go to the Labor Department when an employer has caused them harm. There's a number of ways that they can seek redress, and so I cannot support this legislation for a number of reasons, but it's disappointing to me that we make that assumption here, and I thank you for indulging me.
Thank you, Representative Weir. Representative Hughes.
Thank you, Madam Chair. I'd just like to add some nuance to a couple of statements which I totally agree with. One is that the landscape has changed in the past year since we heard this bill before in labor, and with the a lot of costs rising, I think that especially employees of the larger corporations, 500 employees or more, are more subject to cost-constrained measures, which maybe wasn't as acute last year when we were hearing that. One of the major cost drivers is, of course, providing benefits to full-time employees and healthcare costs and other benefits. So there may be more of a drive to just keep people part-time that really want to have more full-time employment, stable employment. So I think that creates a different risk pool than what we were in terms of people really looking to be exploited, especially also with the use of technology to just generate schedules. And when we see that, especially the lower wage workers that are really struggling to find childcare on short notice and those kinds of things, in those healthcare settings, I think those are who we are trying to protect, those skilled nursing and healthcare settings where we need direct care providers 24/7, which I think you're right. Most employers really try to work with their employees to find that sweet spot of expectations and not pull people in last minute if they don't have to. Of course, we've seen a lot of that with these snowstorms and so forth. We're trying really hard, I think, in that healthcare sector to predict those and to get extra staffing who might be forced to stay overtime so that, people aren't caught off guard, especially when they need to get home to their families. So I think that's what this bill attempts to do. One of the other things that you raised was those good faith efforts, and I think this bill attempts to strengthen existing labor laws like the good faith efforts about saying, hey, it's going to be probably 20 to 25 hours a week, but if it consistently moves into full-time over 30 hours a week, really the employers are supposed to offer full-time benefits and full-time employment to those people. So it's not explicit in there because that's already labor law, but we're trying to kind of strengthen that and not just consistently go below that when people want more hours and want more stability. Again, I think this tries to braid that, thread that needle with not penalizing employers, but also those large corporations that aren't as personal with the boss about, like your daughter's pizza place, really communicating about what those availabilities and those needs are and those responsibilities for those workers. I mean, a lot of the workers in that direct care, public facing or direct public service really don't communicate with have the opportunity to communicate those kinds of needs to their boss directly. So I think this tries to address that as well. But I will agree that there could be some simplification of language that could clear that up for employers that are like, what the heck, So that's all I wanted to say. Thank you, Madam Chair.
Thank you. Seeing no other hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 4, Senate Bill 436, an act concerning advance notice of an employee's work schedule by an employer. This is a motion to JF to the floor. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson. Senator Sampson. Representative Weir.
No.
Representative Hall.
Yes.
Representative Hughes,
Yes.
Senator Lesser, Representative Canino,
No.
Representative Gauthier,
Yes.
Representative Mastro Francesco,
No.
Representative Shake. Thank you, Madam Chair.
We'll be holding votes open. I will move on to item number 5, House Bill number 5278, an act requiring uninsured and underinsured motorist coverage for Department of Transportation employees. This is a JF to the floor. Is there a motion?
Second?
It's been moved and seconded. Any comments? I know we've heard testimony on this last year, and unfortunately, we did move this out of our committee last year. Unfortunately, it did not make it through the whole process, but I believe there's a lot of common agreement in this committee that we need to protect our Department of Transportation workers who are in such dangerous jobs, and that they should have the coverage that we have for our state police in similar circumstances where they're out on the roads and they get, unfortunately, there's a fatality, and the motorist was not insured or was underinsured. So I believe the reason why there's no discussion here is because we talked about this last year and we found we had common ground. So with that, I'll ask the clerk to take the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 5, House Bill 5278, an act requiring uninsured and underinsured motorist coverage for Department of Transportation employees. This is a motion to JF to the floor. Senator Kushner,
Yes.
Representative Sanchez. Yes. Senator Cabrera, Representative Wilson,
With
Sen-
a stop sign.
Senator Sampson, Representative Weir,
Yes.
Representative Hall,
Representative Hall is yes.
Representative Hughes,
Yes.
Senator Lesser, Representative Canino,
Yes.
Representative Gauthier,
Yes.
Representative Mastro Francesco,
Yes.
Representative Shake. Thank you, Madam Chair.
Thank you. Moving to item number 6 on the agenda, HB number 5279, an act adding witnessing a serious physical injury as a qualifying event for purposes of post-traumatic stress injury workers' compensation coverage. This is JF to the floor. Is there a motion?
Second?
It's been moved and seconded. And any discussion? Representative Canino.
Thank you, Madam Chair. This is a very difficult one because it deals with a very serious matter, which is PTSD and PTSI. And this issue has a pretty long history in Connecticut law, most recently dating back to 1993 and expanding since then in 2019 and 2023 to various different classes of employees and for various different expansions, including to PTSD. What I fear we may be doing here today is expanding this statute a little bit too broad, and I want to get into that on line 104. Let me just pull this up here, where we're talking about a qualifying event under subsection C for qualifying event for determining PTSD coverage under our workers' comp laws, saying on and after October 1st, 2026, someone who witnesses a serious physical injury to a person that does not result in death of such a person or the loss of a vital body part or a vital body function that results in a permanent disfigurement of such person. Through you, Madam Chair, are we operating under a specific definition of serious physical injury in this legislation?
I believe that that phrase was chosen to describe, a matter that was very serious, and so I believe that's the intention. I think we've had some testimony about that, and I think we'd all agree in those instances that there was serious physical injury.
And I appreciate the intention. I just, when we're talking about laws, I really want to be specific here because the last thing we want is for this to be overly broad. Elsewhere in Connecticut general statute, serious physical injury is defined as a physical injury to a person that does not result in death of such a person. Actually, let me just make sure I have it. No, sorry, wrong definition. Serious physical injury definition is physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. So we're talking about a type of injury that creates a substantial risk of death but does not actually cause death. So through you, Madam Chair, would a heart attack count as a serious physical injury if it were witnessed on the job under this legislation?
I believe it potentially could be, but again, it would depend a lot on the circumstances. And I think that's why it's not just that somebody witnesses a serious bodily injury, but as a result of that experiences PTSI. So I think there could be a circumstance where something was, an incident occurred that was, perhaps the person was not killed, but the person that was standing next to you was, so it was so shocking and so horrific that the person experienced a heart attack, which I think in those circumstances could be determined to be a serious bodily injury.
And I appreciate that answer because from my reading of this legislation as proposed, if I'm at work and I witness a heart attack, which can cause serious physical injury. I mean, the lack of blood flow to certain tissues can cause serious damage. I think absolutely it would qualify as a serious injury. And we have to be careful that we do not open up our statutes for any loopholes or potential abuse in the system where a certain nefarious actor could basically get one up on the system, where they witness this happen at work. These claims can be very subjective in nature. It's not like if you break your leg or you're shot or have certain physical injuries where there are certain metrics that can be objectively used to determine this. The issue with this situation is that it is very subjective, and that is why I believe the language has been very limited in the past. But in this instance, you can have some pretty I don't want to say routine incidents, but heart attacks are unfortunately very common in our society. There are certain other medical episodes that someone can go through in the course of a workday that I think definitely could cause physical injury, that I think we'd be opening this up very broadly and wildly expanding the amount of claims that can be submitted. I don't want any of these comments to be taken in a way of diminishing or minimizing the experience of someone who witnesses these instances. I think it's very difficult and very traumatizing in cases. However, the last thing we want to do in this state is threaten the solvency and the sustainability of our workers' comp fund, which I believe has been headed down the absolute right track for the past 20 or so years, where we've actually seen costs on businesses and costs on employers decreasing. I fear that a expansion as broad as what we're discussing here, which we'll get into further in a second, could really put us in a tough spot. My next question, through you, Madam Chair, is: does this bill require the traumatic event to be related to the employee's duties, or within, or to happen within their place of work? Through you.
I want to be sure I'm making the right distinction. Would you repeat that?
Certainly. The witnessing of a serious physical injury, when that takes place, and for it to be covered as a qualifying event, does it have to take place within the duties of that employee's, within the course of that employee's duties during the workday, and within the physical workplace that they are in?
I am envisioning situations where it would include both. For instance, say you worked in a bank and the bank was being robbed and all of you were held at gunpoint for hours, and you would be in the bank because of your work duties, because you work for the bank. You would be in the workplace, and you gave an example earlier of somebody having a heart attack, and you could have a coworker or a customer who, after hours of being held at threatened at gunpoint, suffered a heart attack, and you were the person holding them. I could envision a circumstance like that where somebody could end up with PTSD, and I think that would be covered under this bill. That's the best way I can answer it.
I appreciate that, and that is definitely sufficient for the question. What I'm envisioning, though, is a little bit broader, where, let's say I work at a McDonald's that is facing a roadway and I witness a car accident outside of my workplace. And the person there, they are not killed or seriously disfigured, but they receive a serious physical injury. Through you, Madam Chair, would that be considered witnessing a serious physical injury and a qualifying event under this bill?
And where you were diagnosed, I assume, with PTSD? I think that would be up to the work. I think that's the kind of case that the workers' compensation commissioners would have a good idea of whether or not that would apply.
I appreciate the response. However, I believe the workers' comp commissioners would be operating based off of the language that we have here. And since the language that we have here is very broad, I believe that they would almost be bound to make a decision in this case that that would cover. And to an even more, I would say, ridiculous scenario that I wanted to bring up that I believe would be covered under here. Let's say I am a security guard. We'll pause.
I'm sorry, go ahead and repeat the question.
No worries. Say I am the reason I asked about does it have to physically take place in the workplace is for this next line of questioning, which is, let's say I'm a security guard and I'm doing, in my normal course of duties, I'm sitting at my desk, very long hours. I'm allowed to watch a little bit of YouTube or TV while I'm at my job. And I watch basketball. And there's a very famous incident in 2013. There's a basketball player named Kevin Ware who suffered a double compound fracture during the course of playing that game. Where on live TV, both his legs snapped and had bone protruding through the skin. Very, very awful. And that's a potentially life-threatening injury. That's a serious physical injury that could have caused him death. Thankfully, it didn't. But if I witnessed that on the TV during my course of work, would that be a qualifying event under this serious injury, witnessing serious injury requirement that we have in this legislation?
I don't think that would be determined by any commissioner to be a qualifying event when they're watching TV on the job, which is pretty unlikely that they would acknowledge that they were watching TV. Even when you're a security guard, I think the assumption is you're paying attention to your work and not watching TV. I mean, I think you could present a bunch of very outlandish occurrences like you just presented, and it seems like it would be absurd to assume someone would get PTSD from watching that on TV, but very unlikely, I think, that they would be found within this language and within the meaning and the intent of this bill to be found as having PTSD and being on the basis of a work-related injury. I just think that's kind of outlandish. I think, we could think of some probably gray areas, and I think that happens in law all the time, that there are gray areas and that you end up sometimes winning and sometimes losing when a case like that in workers' compensation. But I think the example you gave was pretty far-fetched.
I would agree, and that's why I brought that up and many others, because as written, this language is very broad. And yes, there is the caveat that the individual has to be officially diagnosed by, I believe, a practitioner with PTSD, but due to the inherent subjectivity of that diagnosis, it is not outlandish that someone could get a PTSD diagnosis from a practitioner after witnessing something on the television, for example, especially if it's something related to something that happened in their life. I'm no medical expert, but I believe that there are certain predispositions that someone could be, if they witness a similar event to something that happened to them, could create could more likely create a PTSD diagnosis. And because of how broadly this is written, limiting it to just witnessing a serious injury, and not really many other guidelines in the legislation other than that, there are some pretty outlandish cases that I believe, under the strict letter of the law that we have here, would qualify for coverage. And when there are loopholes, people abuse them, people learn about them, and what you will see, I guarantee it, is an explosion of cases under this law because of the subjective nature of it. Because, you know, with a broken bone, with an X-ray, you can prove you have a broken bone. With PTSD, it's what you report to the practitioner there. And so we've been going long enough here today. I'll wrap it up just by saying that I seriously commend the intentions of this legislation and believe that it is a noble goal to provide compensation and to help financially out people who are suffering from PTSD, because it is a horrible thing to go through. I've witnessed it time and time again. However, at the end of the day, I think this could be much more clearly and carefully written as to not potentially put the solvency of our workers' comp system, or I don't know if solvency is a good word, but the integrity of our workers' comp system at risk. As we've seen premiums, like I said before, continue to fall. It's one of the few business indicators in this state that is going well. And we would really be reversing that. You know, what began initially as a negotiation of expansion in 2019 has just seen in just 7 years an expansion to more first responders and to all employees for witnessing an actual death and disfigurement that ends in a serious injury that ends in permanent disfigurement. This, I believe, would be a broad expansion that I believe would be deleterious to the business climate we have in this state. So thank you, Madam Chair.
Any other? Senator Sampson.
Thank you very much, Madam Chairman. I want to thank Representative Canino for his excellent remarks today. I think he made a lot of very strong points. And I wasn't really going to speak on this bill. I have a similar view, which is that I think that we're all in favor of making sure we provide this coverage when it's actually justified. The concern is that the way the bill is written, there is going to be the potential that this is abused. I found very interesting from the conversation that the chairman had with Representative Canino was this reference to this situation about the bank robbery and the heart attack. You know, it was quite clear to me when the chairman responded that the issue that was causing the trauma was not the heart attack at all. It was the bank robbery. And I note that bank robbery is not listed in the bill. You know, that's the problem here. If we could set up a set of parameters that were sensible when we made this policy to say, if someone legitimately has PTSD as a result of something on their job, then it's covered. But what we're saying instead is we're going to come up with all this laundry list of potential things that could happen that may or may not be significant enough to cause PTSD, but we will include them as qualifying events. And that's what's dangerous. And we've expanded this bill repeatedly. We come back every year and we add another sentence to this bill. Well, let's add these people. Let's add these people. Let's add these people. And that's fine, except now we're down to somebody witnessing something happening to someone else that is a serious physical injury. And a serious physical injury could be something that's not even visible. And yet, if that's what a court ends up deciding to determine whether or not someone's eligible, they're going to be found eligible. And what really should be the determining factor is, do they have PTSI? And do they have it as a result of that incident? That's what should matter. And I don't think that there's enough protections in this bill. Madam Chairman, can you point to me the language that says at what is the determining factor from a diagnosis standpoint, where that language appears in the bill, through you?
I'm not sure if this is what you're referring to, but there is a definition given to the person the mental health professional who would make the diagnosis on line 32 of being a board-certified psychiatrist or psychologist licensed pursuant to Chapter 383 who has experience diagnosing and treating post-traumatic stress injury. Is that clarifying is that what you were looking for?
Well, thank you very much, Madam Chairman. I saw the definition of mental health professional, which is a worthwhile conversation in and of itself, but I don't see any language in here that says that they're making a diagnosis. I assume it's got to be here someplace, but I've been looking through the bill while also trying to listen, and I haven't seen it.
Well, give me 1 second, and
Sure.
I'm sure we can find it. Thank you, Senator Samuelson. You did not find it because, in this bill, because it's in the underlying law.
Thank you very much, Madam Chairman. I suspected that. Can you show me where it's referenced and what that statute is so that we can take a look at it? It might help us better understand what the series of events is that leads to a qualifying situation.
I'm sure I can. I will go and get it for you. How's that? That'll make it even better. Let's print it out for him so he can have it. I don't know if you can do that. We'll just take a break for a few minutes while that gets printed out for you.
I really appreciate that.
Of course.
It's in the interest of
Oh,
clarity,
it's totally
Madam Chairman. I
acceptable.
just want to get it right.
I know. Cameron, he's going to send that to you if you would.
I'm glad you took a nap, Manny.
I guess.
That was the worst one. He's on Wednesday.
You gonna watch the game tonight?
I don't know.
That's not tonight. It's not tonight.
Thursday night?
It's Thursday.
Well, no, tonight's Thursday.
Tonight is Thursday. I don't even know what day it is anymore.
Are they playing tonight?
Yeah.
Okay.
They have to play tonight. No. No, I could be wrong. They get a bye.
Yeah.
It's tomorrow. It's tomorrow. My friends are all down there right now. So I just I'm
Just call them former friends.
Well, they were trying to convince me to go. I told you about this, and then I thought I had an event Saturday, so I didn't go. And then they moved the event to the following Saturday, and I was convinced that it was more important to be at this event from my uncle, by the way. And he's like, "You can just watch the game from home. This is too important." And then they move it to the following week.
Okay.
For the conversation.
Yeah, we're back on the record, and after looking at the underlying statute, it is clear that that there are provisions in the underlying statute that would, I think, address some of the concerns that were raised by the questions that were asked. That there has to be, it's more defining in saying a qualifying event was a substantial factor in causing the injury. The post-traumatic stress injury didn't result from some kind of disciplinary action that was taken. And so I think, I think that the people who are working at the commission have experience, hearing these cases when they're brought to them, and do make those determinations as to whether or not this was a legitimate case of workers' comp, or whether someone is looking to defraud the system, which I think was the concern that was raised. And so I hope that after looking at that underlying language in statute, that we can move on, and that there'll be a better understanding of what we're intending to do here, what we're attempting to do here, and maybe we'll reach some agreement today. Senator Sampson.
Thank you very much, Madam Chairman. I appreciate the answer, and I appreciate you taking the time to let us dig in a little bit to the reference statute in the bill that is before us. And I'm certainly satisfied with this underlying existing statute that's quite clear. It just simply says that a diagnosis of PTSI is compensable as a personal injury if a mental health professional examines the eligible individual and diagnoses such individual with PTSI as a direct result of qualifying events, which is what we're debating. And I'm also aware that the reference to mental health professional that is in the underlying language references a Chapter 383 of our statutes, which makes it clear this has to be a licensed psychologist, which I'm pleased is relatively narrow as well. I'm very sympathetic to this legislation, although I think that our debate, particularly listening to Representative Canino, has revealed some flaws. And I think the flaw is that we keep trying to create a list, an all-inclusive list of qualifying events. And I think in our zeal to find a list of qualifying events, we are missing the mark. I think that if you are in the line of duty and you are faced with circumstances that result in enough trauma to cause PTSI, then you should be considered to have had a qualifying event. I'm not against that, and I don't even know why we've gone through this exercise of trying year after year to close little bits of loopholes as far as that goes. But I will also say that on the other side of that coin is that by simply suggesting that you have to be diagnosed with PTSI by a qualifying individual leaves it really in the hands of that psychologist whether or not someone's going to have the eligibility for these benefits. And I don't know that there's a way that we police that. I don't know that there is an investigative unit for workers' compensation to make sure that people that ultimately are awarded these benefits are actually entitled to them. I don't know if there is a mechanism to take those benefits away if they were awarded in error through some sort of fraud. I don't want to limit the availability of this coverage based on those concerns, frankly, but I do believe that they are real. I also want to suggest that so many things occurred in our conversation that lead me to believe that the language of the bill is less than satisfactory. There, I already brought up the bank robbery example, where it was the bank robbery and not the heart attack that the person was having that generated the trauma, and we have not added bank robbery as a qualifying event. But there's also the circumstance that was mentioned about, watching the television program while on duty. Some people watch television programs while on duty. It's may become part of the job. What if an officer is required to watch some horrific surveillance footage? What if a security guard, well, I don't know if that necessarily applies in this case. Actually, I think it does, is watching something on closed monitored television that is traumatic. I find it hard to believe that you can really watch anything on TV that's going to reach the level of PTSI after the movies and TVs we're all watching every night. But nonetheless, the possibility exists, and ultimately the decision is based on a diagnosis. The diagnosis is the key. And I want it to be that way. I want to have a very broad, open potential of possibilities for qualifying events, much more broad than what is here. I think the attempt to narrow this down to qualifying events has two effects. One, it proves to us every year when people come to us with testimony, as we heard this year, that something that I think everyone around the table would have agreed was a qualifying event was not a qualifying event because we missed it, right? So that's one danger. And I think even after we add this one, we're still not capturing every potential qualifying event we might agree to. But the other side of that coin is that what are we doing to make sure that we are policing the actual diagnosis and the awarding of the benefits afterwards? I don't have an answer for that today. I think what I'm going to do is be very sympathetic to this legislation going forward, and be very willing to work with the chairs to try and find a solution to this event, or to this problem that the bill is attempting to fix. But I am going to flag it with a no vote today because I don't like the language. I don't think it's ready for prime time. I think the limitation of various qualifying events that's not all inclusive is problematic. And I think the main danger is that, as the chairman mentioned, these things are going to be adjudicated by workers' compensation commissioners. And when we start to misdirect the commissioner to be looking at the qualifying event instead of the legitimacy of the diagnosis, I think that's a problem. I don't want the commissioner to be like, well, wait a second. Did this happen in a case where you witnessed someone face a serious injury, but they didn't die? Okay, you fit the letter of the statute, and we're going to make sure that we're going to receive benefits. I don't want that. That's crazy to me. What they ought to be worried about is whether it's a legitimate case that can be construed as the proper level of trauma and the legitimacy of the diagnosis. Those two things are what the workers' compensation commissioner should be adjudicating, in my view, and that's the way we should write the policy. So as I said, I'm going to be a no today, but I am very much open to this. I'm certainly sympathetic to the circumstance that we heard about in the public hearing, and I have an open mind moving forward. So thank you.
Thank you, Senator Sampson. And I do want to, this conversation has caused me to go back and think about how we got here. And I believe, long before I entered the legislature, and maybe even before I moved to Connecticut in 1993, when there was the major reform of workers' compensation, I think prior to that, there was wider coverage for PTSD. I'm not sure there was as much understanding then of what PTSD is, but there was broader coverage and it was taken out. That's my understanding, and there's people here who know more. When I entered in 2019, there had been a discussion for several years between legislators and primarily, as I understood it, organizations representing cities and towns, CCMs, COST, those kinds of organizations that had really negotiated what the qualifying events would be to now have much more limited benefits under PTSI. We're talking about it here and forgetting that the actual benefits that were part of the 2019 resolution and statute were more limited than other workers' comp benefits that you might receive for injuries. And so that was all part of a process that was heavily negotiated, and I wasn't part of it, even though I got to stand up at the end, bring out the bill, I really wasn't part of those negotiations, but I think the reason that we keep adding on qualifying events and adding in groups of employees, and now that we're at all employees, is because we've recognized that PTSD is a real thing, and it can be, and it is important to address, and it can result from something that happens at work. And so, you know, we probably have more agreement on the idea that this should be applied universally to someone who, in the line of duty at work, there's an event that causes PTSI, and that's a real injury that we should address. But I'm not sure we could get enough of our colleagues to agree, because they will be heavily lobbied by employers who are concerned about the cost. And so, you know, this is an attempt to address what was clear from the testimony, a situation where we should be providing that kind of coverage to that worker. And I think we could all come up with good examples of where we would all agree this is something that resulted in PTSD, and therefore we should cover it. But, you know, we're making efforts to move along and address problems as we can and as they come to us. It's not necessarily the best way to do it, but I think it's the only way we could probably get something done. I understand. So thank you for your comments, and I think it's been a worthwhile discussion. I see no other hands, so I would ask the clerk to take the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 6, House Bill 5279, an act adding witnessing a serious physical injury as a qualifying event for purposes of post-traumatic stress injury workers' compensation coverage. This is a motion to JF to the floor. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson.
Yes.
Senator Sampson.
Sampson is no.
Representative Weir.
Nope.
Representative Hall.
Yes.
Representative Hughes.
Yes.
Senator Lesser. Representative Canino.
No.
Representative Gauthier.
Yes.
Representative Mastro Francesco.
No.
Representative Shake. Thank you, Madam Chair.
Thank you. We'll be holding votes open to be determined at the end of end of our agenda what time we'll close the voting and adjourn the meeting. Moving on to item number 8, House Bill number 5384, an act concerning hazard pensions for certain judicial employees. JF to the floor. Is there a motion?
Seconded.
It's been moved and seconded. And are there any questions or concerns or comments? I see. Up. I skipped number 7, but we'll do number 8 since I called it and we've moved it. Since I've already called it, we've moved it. Now, giving you an opportunity to look, we're on item number 8. Are there any questions or concerns? Seeing none, I'll ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 8, House Bill 5384, an act concerning hazard pensions for certain judicial employees. This is a motion to JF to the floor. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson. Yes. Senator Sampson.
Sampson is yes.
Representative Weir.
Yes.
Representative Hall.
Yes.
Representative Hughes.
Yes.
Senator Lesser. Representative Canino.
Yes.
Representative Gauthier.
Yes.
Representative Mastro Francesco.
Yes.
Representative Shake. Thank you, Madam Chair.
Okay, we're going to go back on agenda item number 7, and I assure you there was no intention in skipping that, just that I checked off twice. Item number 7 is House Bill number 5274, an act concerning the workers' compensation system. This is JFS to the floor, and it's LCO number 3174, and that is a different number than was posted because there was a later change made. I do want to mention that this is one of those concepts that we raised that sometimes referred to as a placeholder or a dummy bill. But in the course of taking testimony about workers' compensation, we did have testimony and found that there was a need to address workers' compensation, and therefore there's the LCO 3174 before us. I just want to comment on that briefly because we haven't discussed the concept in previous meetings, but this will remedy, I think, what was language that is no longer germane in statute that in the past referenced high sheriffs, chief deputy sheriffs, deputy sheriff, or special duty sheriff. Those titles are not the titles that are in use today, and they are replaced with is a state marshal. So we have taken up the issues of state marshals. We heard testimony from a state marshal. So that would provide workers' compensation in lines 3 through 8 to the state marshals. The second part of this that is important is making sure that when a state marshal is out on workers' compensation or in the instance where they're out on paid family medical leave, that would be interpreted as time worked. Otherwise, they could be in a position of losing the health benefits that we just figured out they needed to have last year. So those are the two aspects of this that will be addressed in this bill, and I look forward
So moved.
to a motion and a second, and any comments or questions. I see no hands, so I will ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on agenda item 7, House Bill 5274, an act concerning the workers' compensation system. This is a motion to JFS to the floor, and the relevant LCO is 3174. Senator Kushner.
Yes.
Representative Sanchez.
Yes.
Senator Cabrera. Representative Wilson.
Yes.
Senator Sampson.
Sampson is yes.
Representative Weir.
Yes.
Representative Hall.
Yes.
Representative Hughes.
Yes.
Senator Lesser. Representative Canino.
Yes.
Representative Gauthier.
Yes.
Representative Mastro Francesco.
Yes.
Representative Shake. Thank you, Madam Chair.
Thank you. Moving on to item number 9, House Bill number 5385, an act concerning undue delay in workers' compensation claims by police officers and firefighters. This is a JFS to the floor, LCO number 3060. And I want to comment briefly on this. We had this concept raised as a study previously by workers' compensation. In conversations with workers' comp, we've realized that they don't necessarily have the information they would need to conduct the study. And so the S language turns this into a task force. And I think that this is a really great idea. I know this came from one of my colleagues in the House. And I think we have heard about undue delays in workers' compensation for quite some time. We've never been able to figure out a proper way to really streamline or make sure that the process, there were no unnecessary delays. And this will now create a task force of people who have the experience and have the knowledge to sit down and see if there is a way to improve the workers' compensation system. We've heard from constituents about frustrations they've had. We also know on the other end of it, we want the commissioners to really be able to take a close look at each case that comes before them. But perhaps through getting people in the same room, there'll be an opportunity to find effective ways to improve the process. I do want to make a comment that this discussion took place late in the day, and so rather than really putting together the task force membership as we might want to see it, we put in the standard template of a task force. So I would invite people to think about what would make sense so that we can refine through amendment once this gets to the floor and have a task force that will really be effective. So I think we're open to seeing some changes in that. So with that, I will ask if there are any questions and concerns. I already took a motion and Okay, so moved and
Seconded.
seconded. Is there any discussion? Seeing none, then I'll ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 9, House Bill 5385, an act concerning undue delay in workers' compensation claims by police officers and firefighters. This is a motion to JFS to the floor, and the relevant LCO is number 3060. Senator Kushner,
Yes.
Representative Sanchez,
Yes.
Senator Cabrera, Representative Wilson,
Yes.
Senator Sampson,
Sampson is yes.
Representative Weir,
Yes.
Representative Hall,
Yes.
Representative Hughes,
Yes.
Senator Lesser, Representative Canino,
Yes.
Representative Gauthier,
Yes.
Representative Mastro Francesco,
Yes.
Representative Shake. Thank you, Madam Chair.
Thank you. Moving on to item number 10, House Bill number 5386, an act requiring paycheck transparency. This is a JF to the floor. Is there a motion?
So moved. Second.
It's been moved and seconded. We've had this bill before, and my understanding is there's no change from the bill that we JF'd last year. Are there any comments or questions? Seeing no hands? Seeing no hands, I will ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 10, House Bill 5386, an act requiring paycheck transparency. This is a motion to JF to the floor. Senator Kushner,
Yes.
Representative Sanchez,
Yes.
Senator Cabrera, Representative Wilson,
Yes.
Senator Sampson,
Sampson is no.
Representative Weir,
Nope.
Representative Hall,
Yes.
Representative Hughes,
Yes.
Senator Lesser, Representative Canino,
No.
Representative Gauthier,
Yes.
Representative Mastro Francesco,
No.
Representative Shake. Thank you, Madam Chair.
Thank you. Moving on to item number 11, House Bill number 5387, an act concerning disclosure of wage ranges and benefits on public and internal job advertisements. And this is a JF to the floor. Is there a motion?
Second.
It's been moved and seconded. We've had this identical legislation in past years as well. Any comments or questions? Senator Sampson.
Thank you very much. Madam Chairman, yes, this is an extension of a law that we passed several years ago. I know you and I debated it at great length on the floor of the Senate. And it's because the underlying statute, to me, is nonsensical that I don't agree with the expansion of that policy that is before us in the bill that we're looking at. This is all about requiring employers to provide information, which I don't think is ever specific enough to warrant the obligation to disclose it. And then, much like the other bill that we discussed today, I think it's a litigator's dream because the bill is filled with all sorts of terms that are going to be argued about. You know, what is a general description of the benefits to be offered? Who's going to argue whether that description was specific enough? And then to actually create some pretty harmful reactions by the state government to the employer's failure to live up to what I consider to be impossible to live up to requirements. The addition of all those provisions, to me, makes this a very hard thing to vote for. I think people that come up with these types of policies are so divorced from what's happening in reality that they just don't understand. I mean, that's the only way I can put it. You know, I've been in a number of different industries. I used to work for a company that owned small insurance offices, actually, and I had the opportunity to hire a great many people for different office locations and so forth. And we almost always had some job posting for something going. But what would happen is we would get applicants that didn't naturally meet the exact requirements, but maybe sometimes they were somebody that could do far beyond what we were looking for, and we actually created a position for them. Or maybe sometimes after reviewing all the applicants, we sat down and said, you know, we didn't find someone for this role, but you know what? If we take person A and person B and we move them over there and then we do this, that person, we can make a role that fits them. that kind of thing actually happens in the real world. That is how business operates. Not everything fits into a cookie cutter example. I think this stems from the same exact kind of DEI mentality, which is that, oh, well, we need to have a certain person from each background to fit into a category. That's got nothing to do with reality. What we're looking for in industry, and this is employers and employees, is the right fit for the position. It's somebody who actually is going to fulfill a job responsibility in the right way. And everyone has strengths and weaknesses. This also implies that everyone that works at a company that has the same job title should be paid the same amount. That's an absurdity. It also implies that people are going to naturally fit exactly into a job description and a salary range. And I don't think any of those things are true. So trying to make it happen by law, to me, is somewhat absurd. This bill, like I said, is just an extension of what already exists by now requiring that not just salary range, but also benefits are itemized in the disclosure. Just looking at the bill, I mean, I see other things, in good faith. I mean, again, lawyers are going to make a mess out of this if given the opportunity, in my view. And I don't think that this bill really creates a better economic situation for anyone. I don't know how this creates a job. I don't know how this protects employment. I don't know how this protects opportunities for employment. If people are going to say, well, this disclosure is going to help someone be able to advance themselves by making the prior pay that they've earned something separate from what the job posting might be. At the end of the day, it all works out that employers are going to try and hire the best quality people at the best possible price that they can, and employees are going to try and get paid the most for the job that they do. And nothing's going to change that. Not some words on a paper or some artificial requirements about the posting of salary ranges, especially when there's no actual requirements. The requirements are, that you have to do it in good faith and you have to provide a general description. Well, I'm going to pay them more than $1 and less than $1 million. I'm certain that would not pass muster. I mean, but what does pass muster? And do we leave that up subjectively to some court down the road? That's not good policy for anyone. Laws, as I've said countless times, should be written clearly. They should apply to everyone, and everyone should understand what they are. I don't understand this. Madam Chairman, I'm going to vote no because I don't understand it. That's my statement for the record. Thank you.
Thank you. Any other comments? Questions? Representative Weir.
Thank you, Madam Chair. I won't spend too much time, but I have a couple of questions, and I thank Senator Sampson for his thoughtful remarks. In, I guess this is Section 2. I'm sorry, Section 1, Subsection 2, the description of employer. I went through that entire list. Is a municipality, where is municipality listed or covered in this list of employers?
I do want to point out this is underlying statute. But if you'd like, I can take a pause and we can get an answer for you.
Thank you, Madam Chair. And forgive me, I was looking at Section 1 where it says the general, I always get sometimes tripped up.
I know.
General statutes
Easy.
repealed and the following is substituted in lieu of. I would like to know if we could just get a clarification. Sure. Does employer include a municipality?
Go over there because I think it's clear in here because it says any political subdivision thereof. Isn't the political subdivision the description of municipalities and state and all that?
Thank you. So that's not a subdivision of the executive. It's not a state the way I read this was the state of Connecticut and the political subdivision.
So
was
I
the
think
different
that's the
branches.
standard language for when you say the state and any political subdivision. The political subdivision are all the
Thank you.
other municipal entities.
Thank you for that clarification. Yeah, I would just like to agree with Senator Sampson that this is so broad, it's going to lead to division. I completely agree that as an employer, you know, we wanted to, when advertising a job, you want to make it specific, because I don't want 100 applicants when 97 of them are unqualified for the job. But that is, you know, a best practice. That is, you know, if the employer wants to waste his or her time interviewing 100 people when only 3 of them are qualified, I would think that the employer would eventually learn to tighten up the job description. But that's not something that should be mandated here with penalties attached. Certainly employees, you know, as a job applicant at times myself, when you're looking for something, you know, I can only speak for myself. I would avoid something that was overly vague, and I'd be looking for the job description that hones in, so I'm not wasting my time. And I think between the two parties, they can figure it out themselves. There's absolutely no reason to create a confusing law that, again, pits them against each other with penalties. So I'll be a no today, and thank you.
Representative Kin-
Thank you, Madam Chair. And just to be brief, I have no questions for the proponent. At the end of the day, what we're talking about is a negotiation between employers and employees. And we are requiring one side of that negotiation to tip their hand, which I believe is unfair. You know, before joining the legislature, I actually worked in this building and covered some press conferences where questions would be asked of senior legislators of certain policy, and the answer would be given, oh, well, we're not going to go negotiate in public. You know, there's a whole process. Well, it seems like we're not extending that same standard to our employers who provide so many great jobs in this state, where we are requiring them to submit some information, but not requiring a concession from the other side. It's already state law that you have to provide this info once asked. If you are considering employment somewhere, you're in the interview process and you ask what the salary range is, they got to give it to you. All we are doing here is asking for them to publicly broadcast that out for the world to see, and that can have some serious consequences. It can cause discord among the employees of that company who might be upset that this new job is being hired for a certain amount and they make less than that. But as Senator Sampson eloquently said, people who do the same jobs can be compensated differently based on their qualifications, their efficiency, their longevity at that company, multiple different things. But this will also hurt prospective employers as well. I mean, if an employer is required to set a specific number, that reduces their flexibility. So an employer might be willing to take someone on who has lesser qualifications. Granted that they take maybe not a training wage, but a lesser wage while they're training and learning on the job for the first year, and then they want to take them up to a higher amount the second year. They don't have that flexibility here. Here they have to take exactly, you know, that number or that range of numbers that's given in the first place. And it's going to make employers tighten their belt a little bit and reduce options for people who maybe have fewer qualifications. I remember coming out of college trying to apply to jobs, and it seemed like every entry-level position that required a bachelor's degree would require you to have like 4 or 5 years of experience. Well, how are you supposed to get that right out of college? You need an employer that's willing to take a chance on you and willing to maybe hire you for a little bit less and train you a little bit and take that chance. Here, we're not giving that flexibility. If the job's for $60,000, but I'm not worth $60,000 with my background, but I'm willing to do the job for $50,000 as you know, a trainee, I don't get that flexibility under this legislation. So unfortunately, I won't be able to support this because, one, it puts our employers in a worse negotiating position, which I don't believe is fair, and two, it will inevitably hurt job seekers. So thank you.
Thank you. Any other comments or questions? Seeing no hands, I'll ask the clerk to take the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 11, House Bill 5387, an act concerning disclosure of wage ranges and benefits on public and internal job advertisements. This is a motion to JF to the floor. Senator Kushner?
Yes.
Representative Sanchez?
Yes.
Senator Cabrera? Yes. Representative Wilson? Yes. Senator Sampson,
Sampson is no.
Representative Weir,
Nope.
That was-
Representative Hall,
Yes.
Representative Hughes,
Yes.
Senator Lesser, Representative Canino,
No.
Representative Gauthier,
Yes.
Representative Mastro Francesco,
No.
Representative Shake. Thank you, Madam Chair.
Okay, we have concluded our agenda for today. We are leaving votes open until 5 p.m. For those who are in other meetings and have not had an opportunity to vote yet. Our next meeting of the Labor and Public Employees Committee will be Tuesday, March 17th. And this says 11 a.m. Is that correct? Okay, I had it in my calendar for 10, but 11 is fine with me. So if everybody's okay with that, then we will see you next week at 11. Take care.
Representative Hall, I'm missing a vote on agenda item 1 from you.
Yes.
Thank you. And I see that Senator Lesser joined the Zoom as well. Give me a moment. Senator Lesser, I have outstanding votes on, I just need to pull this up. Agenda item 6, House Bill 5279. Senator Lesser. Senator Lesser.
Yes.
Agenda item 6, House Bill 5279.
I'd like to vote in favor of that.
Okay. Agenda item 7, House Bill 5274. Agenda item 7, House Bill 5274.
In favor.
Agenda item 8, House Bill 5384.
In favor.
Agenda item 9, House Bill 5385, JFS.
Yes.
Agenda item 10, House Bill 5386.
Yes.
And agenda item 11, House Bill 5387.
Yes.
Thank you, Senator.
Great. Thank you. Have a good day.